The President, please be seated. The trial chamber is now in session. Per our sitting schedule, this morning the trial chamber will continue to hear the challenges by the Defense Counsel and the responses by the Civil Party Council regarding certain remaining Civil Party applications. Before we proceed, the Chamber would like to make an announcement. To the parties to the proceedings, for our proceedings in the future, after we finish hearing the challenges and responses on the remaining Civil Party applications. This morning the Chamber will finish to hear the challenges to the Civil Party applications and the responses thereto. Therefore, the Chamber will be asking brief submissions from the parties on whether the civil parties have a right to question the accused and witnesses on the issue of the accused character. The co-prosecutors will have 10 minutes to make their submissions, the civil parties a total of 40 minutes, and the defense 40 minutes. After an adjournment for deliberations, the Chamber will inform the parties of its decision on whether the civil parties will be granted an opportunity to question the accused and witnesses on character. Following the decision, the Chamber will start questioning the accused. On separate issues, the Chamber has noticed that, especially yesterday, the Chamber noticed the request by the civil parties. Therefore, the Chamber would like to issue a verbal direction for submissions of additional evidence for the civil parties. The trial chamber refers to the oral submission by the Civil Party Council during the morning session on 26 August 2009 regarding their intention to submit to the Chamber evidential material related to the civil party applications and the victims in the case file 001 who have been challenged by the Defense Counsel. In order for the Chamber to have sufficient grounds for its examination and decision referring to the above challenged civil party applications, and in order to ensure an expeditious and fair trial, the Chamber issues the following direction. 1. Civil parties whose applications have been challenged shall submit additional evidential materials to the Chamber to show their relevancy between the civil parties and the victims in the case file 001. Two, if possible, civil parties shall submit those evidential materials to the trial chamber by the latest Thursday, the 3rd September 2009 at 4:30 p.m. Let we now proceed with our proceeding and the schedule this morning. That is the challenges of the Defense Council for the remaining civil parties. The co-prosecutor, you may proceed.
Je vous remercie, Monsieur le Président, Madame et Messieurs les juges. Je voudrais demander l'autorisation d'intervenir 1 minute concernant justement les questions qui seront posées à l'accusé sur sa personnalité.
All right, we're ready.
Merci. Lundi dernier,
Thank you. Last Monday, Deputy Co-Prosecutor William Smith came to the chamber, came before the chamber to inquire about the period during which co-prosecutors might ask questions to the accused with regard to personality or character. We haven't yet received a response from the chamber, and we wish to insist with the chamber so that we may be informed of the time that will be allotted to us, particularly so that we may adequately prepare the questions that we intend to ask. I wish to insist on the fact that this is the last chance that will be given to ask questions from the accused with regard to character and responsibility. It is therefore essential for the prosecution, probably also for the other parties, as well as to ensure that the truth will out and in the spirit of good administration of justice. Now, we are not unaware of the fact that on Monday 2 expert witnesses will be testifying for 1 day and a half, and that the dates at which these witnesses will be heard are difficult to change. However, we wish to suggest that if it is the case that the questions that are asked probably this afternoon from the accused have not been exhausted by the different parties involved, then that these questions may continue after the hearing of the experts on Monday and Tuesday. And thus I ask that enough time be dedicated to the questions that will be asked from the accused, both for the co-prosecutors and for the other parties. Thank you.
The chamber, thank you, Mr. Co-Prosecutor, for your reminder. The chamber would like to remind the international co-prosecutor that the chamber does not forget what was raised by the co-prosecutor William Smith for his request on the time allocation in questioning the accused on his character. Actually, he requested a time allocation of 1 hour to 130 minutes. And yesterday, the chamber took that matter into consideration. And the reason the chamber has not yet responded to the request, because the chamber will have to hear brief submissions by the parties this morning as whether the civil parties shall have a right to ask the accused on his character. And the chamber has to hear the brief submissions by the civil parties first before the chamber can make a decision on the time allocation for each party to the proceeding, because the time allocation will vary based on the decision after the chamber hears the brief submission of the civil party. And of course, what was requested by the international co-prosecutor seems reasonable. That is the time allocation between 1 hour to 1 hour and 30 minutes in proportion to the time allocation proportionate for each party. Secondly, the chamber would like to inform the parties to the proceeding that the scheduling to hear the true experts, which was planned for 1.5 days, that is for Monday, and the morning session on Tuesday, has not been changed. As the time allocation was to respond to the time and date needed by the experts, the true experts. On the questioning of the accused character, which was planned to proceed after we hear the challenges and the responses, and after we hear the brief submissions by the civil parties as whether they have a right to ask questions regarding the accused character, we will start the questioning in the afternoon session today. And if it does not finish, we will postpone it, and after we will hear the testimonies of the two experts on Monday and Tuesday morning session, then we will continue on Tuesday afternoon session. So this is the information for all parties to the proceeding, especially for the co-prosecutors. The President, I hope I make myself clear. Mr. Co-prosecutor, is it clear enough for you now?
It's perfectly clear, Mr. President, so we will await your final decision concerning allocated time until after the discussions of this morning. Thank you.
The President, let me now proceed with our schedule. The Defense Counsel, you may now proceed with your challenges to the remaining civil party applications. There are 6 civil party applications remaining. That is E2/77, who is a civil party in Group 2. You may now proceed.
Merci, Monsieur le Président. Bonjour, Monsieur le Président.
Thank you, Mr. President. Good morning, Mr. President. Your Honors. I will be touching upon E2/83. This is the one we wish to deal with before those that belong to Group 1. In fact, E283 has to do with Mrs. Ong Savat, Group 2, which has not yet been discussed. Please allow me, Mr. President, with regard to a Group 2 case, which goes to Council Strudziński, that we wish that she will get well quickly, and we are very sorry that we have to challenge civil parties in her absence. Concerning a civil party E283, there is nothing at all in the case file. That is the reason why the defense challenged this application. There are no documents relative to kinship, and with regard to the presence of the uncle of Mrs. Ong Savat in S21, the plaintiff mentions a photograph, but the only photograph that was filed is obviously a photograph that was not taken in Tuol Sleng. Thus, we have practically nothing to work on, and that is the reason why we raise this objection. Thank you, Mr. President.
The President, Civil Party Council Group 2, you can respond to this challenge. The Chamber would like to inform the Civil Party Group, Lawyer Group 2, that you have not yet responded to the challenges by the Defense Council for Civil Party E2/77, as you were not ready to respond. Therefore, this morning you can respond to both challenges, that is E2/77 and E2/83, as just raised by the Defense Council. And the E2/77 was challenged, and the reasons were given yesterday by the Defense Council. You can proceed. Hong Kam Soon. Thank you, Mr. President. My name is Hong Kam Soon. I am a civil party lawyer for Group 2, and my co-international colleague is Strudziński. I am also representing civil party Group 4 with Mr. Chair Olivier Chua. I am now speaking on behalf of my colleague, as my colleague has some health concerns. First, in response to the civil party application E2/77 with the name Kaing Guek, I was absent yesterday as I spent time to do further research on this client. Kaing Guek E2/77, who is my client, but I did not meet her yesterday. I met an intermediary organization, the Khmer Campuchia Krom organization, and I met her relative who told me that this client was frail due to old age, and I actually wanted to speak to her in person whether she wishes to waive her right. Her daughter informed that her mother, waived her right to be a civil party through this 001 case filed. So this is information for the chamber and for the civil parties and the parties to the proceeding.
Regarding another civil party, E2/83, and the defense challenged that there is not sufficient document to prove the kinship, and that the photo was not taken at S21, the photo that is available. I would like to also tell the court that yesterday I tried to contact the civil party applicant through the victim unit, and the photo she obtained and filed here was obtained from S21. However, due to time constraints, I am not yet able to retrieve the photo with the number attached from the chief of the Dual Slime Museum. So if with the President leave, I will submit this document in due course when we obtain the information, and I will preserve to put further documents to support the application. The President, the Defense Counsel, you may now proceed with another civil party, especially the 5 remaining civil parties in Group 1. So there is only one remaining group, Group 1. So the Defense Counsel may proceed with the rest of the 5 applicants, and that the civil party lawyer Group 1 can simultaneously respond to the challenges.
Mr. Roux, thank you, Mr. President. I am now indeed referring to the 5 following civil parties: E2/49, E2/69, E2/73, E2/74, E2/75. Mr. President, my esteemed colleague Alain Werner said to us that he wished to provide explanations regarding these 5 civil parties simultaneously, as long as but there is no document in these 5 cases. Under these conditions, Mr. President, I would like first, therefore, to listen to Alain Werner's explanations, and he told me that they would be of a general nature, and then I would like to address these observations afterwards. Thank you.
The President, Mr. Kaing Guek Eav, you now may proceed.
Alain Werner. Hello, good morning, Mr. President. Good morning, Your Honors. Let me please, before I start, thank the defense, because we agreed with the defense yesterday, and we asked the defense if it would be possible for it not to follow a chronological order. and therefore to group our 5 cases at the end so that we may in one go express our observations on these 5 cases before the chamber, and the defense agreed to this, and we are thankful. Please let me speak to you about one specific case, and then I will refer to the 4 others later. E2/49. So this is Mr. Eng Sita. This civil party told us yesterday that it was no longer interested in taking part in these proceedings, and therefore, according to Article 23, paragraph 10, that stipulates that a civil party can at any moment waive its request for reparations or step out, we would like to inform the chamber that the civil party E2/49 is indeed waiving its claim and is no longer a civil party. So this is for E2/49. Now, let me please refer to the 4 others, E269, E273, E274, E275. As Council Roux said to us in a perfectly appropriate way, the situation is the following. We did not have in January and in February, when we started with the civil parties and when we came to the initial hearing, we did not have any evidence, any biographies, or any confessions. Their names do not appear on the prisoners list. That is so. And a decision on principle was taken by my group back then, which was to maintain the civil party applications, and we were ready in February to explain why, the reason why our stance was such and why we would like to retain the civil applications, despite the fact that there are no biographies, that they're not on the prisoners' lists, and that there are no confessions. So the question was not put to us in February, and I'd like to explain to you briefly regarding these 4 civil parties. Well, I'd like to tell you what is our stance, on what legal base our stance is based, given that we will not obtain extra evidence. It does not exist, so therefore the situation will not change. This is why I would like to bring up these 4 cases now. So our position is the following. Our stance is that if your chamber believes, given the civil party applications, if the chamber accepts the information, if the chamber considers that this information is coherent and are sufficiently detailed, our stance is that in itself this should form the necessary proof according to Article 23, paragraph 5, according to Article 3.5, subparagraph D of the practice directions on the participation of the victims, because nothing in these articles, nor in the internal rules, nor in the practice directions regarding imposes in an automatic way that a civil party has to provide a material evidence, written evidence, to support its civil party application. There is nothing in both of these articles that states this. And if you look at Article 23, paragraph 5, and I will take the liberty of reading this, any civil party application must contain sufficient information and must provide its compliance with the current rules, and must provide useful information on the victim's situation, and include, if necessary, Thank you. And include any evidence that can determine the existence of the harm, if it is necessary. So nothing automatically imposes upon us that we have to provide any written evidence. So, Mr. President, Your Honors, international jurisprudence and in regards to civil party participation, well, international jurisprudence is limited, of course, because this is only this system is only beginning here in international courts. But however, we feel that there's a very strong tendency that is being defined, and in particular by the jurisprudence of the preliminary chamber, and this tendency goes in the direction of accepting indirect evidence to support the civil party applications. If and I would like if the victim can provide the evidence that it was indeed impaired by objective obstacles, to provide the direct evidence or the elements that would support its application. And the preliminary chamber of the ICC continues and tells us that it will decide on a case-per-case basis based on the merit of the intrinsic coherency of the victim's statement and the intrinsic coherence of the victim's statement. And I refer to the decision of Lubanga, the decision of the 10th of August 2007. So it is indeed just a preliminary chamber, but what we're saying here is that there is indeed a tendency that is being formed, which accepts that in certain cases there is no material evidence for objective reasons, and that indirect evidence must also be admissible. So, I would like to tell you one thing here. Mr. President, Your Honors, we are here in international criminal procedures where, and my colleague is very much aware of this, the ICTR over the past 11 years, since the Akayasu jurisprudence that was rendered on the 2nd of September 1998, we are in a field where legal criteria that has says that states that an accused can be accused in an international criminal court on the basis of only one single statement, which is not necessarily corroborated. This is what the Akayasu jurisprudence states, and this is what was confirmed later. And of course, this statement must be credible and must be relevant, obviously. But the argument is that you can convict somebody in international criminal courts on the basis of a statement without any extra evidence, without anything else. And if this is true, well, then it cannot be possible to require automatically that a civil party, beyond what the civil party is stating, to require that the civil party must necessarily provide evidence through a biography or a confession. This is not possible. We cannot require this. This cannot be an automatic rule. So, if you accept, indeed, our submission, if you accept the submission, the criteria that we're proposing to you, that is to say the coherence of the information that our four civil parties have provided to you, this is a very important point for us, this will create no prejudice to the accused for two reasons. The first reason is that our four civil parties are providing no incriminating element, contrarily to other civil parties who testified earlier. These 4 civil parties are providing no incriminating elements against the accused. And number two, the accused, and this is very important, the accused will not be obliged to pay reparations, individual monetary reparations. There will be, therefore, no negative consequences for the accused. Since the 4 civil parties, whether they're accepted or not, this will change nothing for the accused because he will not be obliged at the end of this trial to pay any money to the civil parties. And this necessarily must have an influence on the criteria that you're going to set. So Maître Roux, with his great talent, said to you yesterday, in a direct way, I could say, that in your decision you must consider in case file number 2 or etc., because you will probably be the first ones thinking about this issue that we're bringing up today. Well, he brought forth this argument, and I'd like to say something about it. If you go beyond what is required, what is required by the internal rules or by the practice direction. If you say to yourself, we require as an automatic criteria evidence to support the civil party applications, well then, based on what I understand, and you know that we're not joining case file number 2, but still, based on what I understand, the quasi-totality of the civil party applications in case number 2 will then have to be declared as inadmissible because there is practically no proof, in particular in the detention centers within Cambodia. There is no confession, there's no physical evidence, there's no prisoners list, and that is the consequence. That is the consequence of such a decision as you're bringing up now. And there is something else. We strongly reject, and with all of our respect, of course, that we have for our esteemed colleague, Maître Roux, but we strongly reject the scarecrow argument, the argument that consists in saying, okay, if you decide that indeed there is no need to provide any evidence, well then there will be flows and flows of civil party applications that are going to submerge and drown your jurisdiction. Mr. President, Your Honors, the accused is benefiting from the presumption of innocence. And of course, we must explain to you the reasons why we believe that our civil parties are joined. But our civil parties must benefit from a presumption of good faith. And if this trial has demonstrated one thing, is that there has not been any imposture, there has not been any profiteer among our civil parties. Our clients have all acted in complete good faith. Our clients are not asking for money, and we're asking that our clients can benefit from this presumption of good faith. So, and I'm almost finished. So you remember I mentioned the jurisprudence of the ICC with this idea of indirect evidence being sufficient, that is, say that if indeed a civil party can prove that it was objectively hindered in providing this evidence, well, the evidence that our 4 civil parties can provide to you to demonstrate their good faith, the proof that the proof that they are indeed also hindered by objective obstacles to provide direct proof, such as a biography, a confession, or prisoner's list, well, this proof is the destruction and the disappearance of part of the S21 archives. And Counsel Truus-Naprouus said that to you, and she mentioned what David Chandler mentioned in course, and the international co-prosecutor also mentioned this, and I think that this is even more illustrative than just referring to an expert. I would like to read to you just a few lines of what is present in the case file. And this comes from Nick Dunlop's book. And unfortunately, this book was not translated neither in French nor in Khmer, but it is in the case file. And the index ERN in English 0078697. There are only the two first pages here, unfortunately. I can also give you the ERN in French or Khmer, but that doesn't correspond to anything because there is no real translation. I'd just like to read one single page regarding the destruction of these archives, which is so that you may understand really what the situation is. And I'm going to read it in English. And so, because the text is only in English. So Nick Dunlop is speaking about somebody called Gro, and he says the following.
Found a room near Tuol Tum Pong market with his wife and daughter, and he began to look for work. At the market one morning, he saw women selling fried bananas, wrapped in paper with handwriting on it. There had been no paper during the Khmer Rouge. Now, in the semi-derelict city, it was everywhere. Sheets of it blew through the streets. Children had begun to collect it. He picked up one parcel of bananas. He recognized the handwriting. It was the confession of a friend from Paris. When he asked where he had come from a little boy, the little boy led him down the back street to Tuol Sleng. He saw the weather wire along the wall and Vietnamese soldiers at the entrance and said, "I didn't dare to go inside."
Soldats vietnamiens à l'entrée. Il n'a pas osé entrer à l'intérieur, a-t-il dit.
Mr. President, Your Honors, it's not to try to be funny here, but a part of the confessions or of the biographies was used to indeed wrap up fried bananas in the Phnom Penh markets in the 1980s. That is the situation. That is the reality. So I have finished regarding the 5 civil parties. Yes, indeed, we cannot provide for 10% of our civil parties. We cannot come, indeed, despite our best efforts, we cannot come and provide you the proof, the evidence, but we believe that what our clients are saying is coherent, and we believe that what they're saying must provide sufficient evidence given the circumstances. And here, once again, it's not to be comical, but maybe the biography or the confession of one of our 4 clients was used indeed as well, maybe to wrap up fried bananas or any other kind of foods in the Tuol Tum Pong market in the 1980s. That is the real situation, and that is our submission. Thank you for having given me the time to listen to me.
The President, the Defense Council, you may now proceed in response to the Council of the Civil Party.
Mr. Hu, thank you, Mr. President. Everyone probably has understood that we're now entering a real debate, which has been presented to this chamber since the start, in fact, from this side of the bar, we're trying to respectfully draw the chamber's attention to what might be and what must be the role of the civil parties. And I heard, once again, a lot of confusion in what was just presented to us regarding the role of the civil parties. And I would like us to be clear, and I'd like us to reassure everyone here and to reassure the people who will not be able to join as civil parties. They are represented here by the co-prosecutor's office, and from which we may believe that they will manage in the best conditions possible their applications, their representation, the representations of the interest of society at large. So, whether the civil parties who will not be able for legal reasons, because we are here in a court of law, so that the civil parties who will not be able for legal reasons to be individually represented here in this court, well, they should rest assured they will be at least morally represented by the co-prosecutor's office. Once again, what is a civil party in a civil law trial? It is a person who can justify, who can prove its ability to act. That is to say, it is someone who personally has endured or experienced harm, or someone who is very close to from another person who experienced harm. So that is to say, a parent for a child, or a child for her parent. So someone who has the capacity to act, and someone who has the strong grounds to act, that is to say, somebody who can justify the harm endured. And we are, Mr. President, Your Honors, we are here in a court of law. We are not at the market or in a forum. We are not at the market square where we can throw stones to the accused. And I heard, even from far, when I was in The Hague last week, I heard words that were pronounced here in these proceedings, which were like stones that were thrown to the accused's face. And I suffered from that, because I would like us to remain within the context of a dignified trial, and that everyone stay in his right place. What are we expecting from the civil parties? We're expecting that they say two things to us. Once they will be entitled to do so by law. Two things, not three, two things only. This is my personal suffering, one. And two, this is the memory of the person for whom I'm suffering. And I'm speaking to you about the person who is suffering. And it stops there. The problem is that since the very start, these civil parties want to go beyond their role. Do you remember, as of the very first hearing, my esteemed colleague, Maître Kahn, who was saying to us, civil parties do not exist in my tradition. I'm just discovering this now, and I like it. And I'm going to ask for sentences against the accused. And I'm going to bring in an expert to claim for a sentence against the accused. This is total confusion. I stood up. I stood up, and I stood up against this. And I said it again yesterday. What we are doing here is an extremely important endeavor, because we are opening up a completely new ground, and we are not allowed to be approximate only about this. So, my esteemed colleague, fine, you mentioned the ICC, but you only forget, however, that before the ICC, the victims are not civil parties. They are not civil parties. And I considered, as far as I'm concerned, that here
we are taking a further step. We are making progress, because here the victims are not simply heard in the manner that they're heard at the ICC. They are civil parties, which includes all the rights attached to a civil party status. This is considerable progress, but we are all aware, because we are all jurists, that when one has rights, one also has duties. And the first duty of a civil party is to respect the rules which will enable the civil party to be effectively a civil party or not. And the second duty is to respect the role of a civil party in the course of proceedings. In other words, not to intervene on the issue of the sentence, which belongs to the prosecutor. And in total confusion, you speak of the Akayesu jurisprudence. And I'm quite familiar with it, because I've spent long hours in the defense at the International Criminal Tribunal for Rwanda. But you forget something here. When the tribunal, presided over by the regretted Laiti Kama, who was a great president, when that tribunal ruled on this subject, which I have reservations about personally, it was after having heard the witness in a process of examination and cross-examination, because we are working under full common law procedures in Arusha. This is not at all the case for the persons that we are discussing here. The civil parties that you mentioned did not come. They could not be heard. They could not be contradicted or questioned. So you're not at all in the Akayesu framework. And if you were to go to the very depth of the Akayesu jurisprudence, then you should recall the challenges to the taking of that decision, and recall that the tribunal was very careful to mention and recall that this was exceptional, that such a practice could apply only if there are no other solutions. And in international criminal law, you know as well as I do that the key principle is the principle of corroboration. Exceptionally, in certain specific case, as the tribunal said, because the witness was examined and cross-examined, exceptionally it is possible to accept testimony that is not corroborated. Now, yes, faced with tragedies such as the one we are dealing with here, I agree with you, Mr. Werner. The civil parties must, a priori, be presumed to be speaking in good faith. But one can also be mistaken in good faith. One can be mistaken. We heard at the bar persons who were mistaken, who thought in good faith that they had been incarcerated in one location, whereas they had been incarcerated in another. And you know this very well. So you made an attempt at concluding by reading from the book of Nick Dunlop, but the other day the Office of the Co-Prosecutors thought that it could rely on the exceptional film of Ritipan as evidence. But these are works, a book, a film, and concerning the film of Ritipan, it is eminently respectable in that it is of superior quality. I know of no other film of that quality. Nevertheless, I think that the people who write these books or the scenarios for these films never imagined that they would be used in judicial proceedings, in legal proceedings. We are in legal proceedings. An investigation took place. There are rights and duties. And I repeat, as I said yesterday, dura lex, sed lex, we are jurists. And an eminent law professor stated something that we should never forget. Sworn enemy of arbitrary procedure form structure is the sister of liberty. We are not here to rule in our arbitrary fashion. We are here to tell the law. And I ask the Chamber to apply the rule of law with regard to civil party applications. And once again, to state loud and clear also to the public here that they are fundamentally represented here by the Office of the Prosecutors, who will represent this entire society, which was upended, whose social links were violated, as we know, by the period of democratic Kampuchea. That is the role and the duty of the prosecutor. Do not remove that from his office. Thank you.
The President, Mr. Alain Werner, you can proceed. The Chamber would like to remind the parties to the proceeding the main point of the proceedings at the moment is whether the civil party applications are acceptable and have all the criterion as set out, plus the relevant information. And for the general reasons or other reasons which are going to prolong the proceedings shall be reserved. And that can be used during the final submission, the oral final submission, which would be the appropriate time. Alain Werner, you can proceed, but please adhere to the main point of the proceedings at this stage. And do not just wander into the general observations or general points. Because the general points have been discussed already, but now we are dealing with specific applications on the lack of the conditions before the civil parties can be accepted, and as they are challenged by the Defense Council.
Thank you, Mr. President. I have fully understood what you've said. I have two very, very short points. I'll be very quick. Of course, we understand the difference between
ce qu'il se passe ici et ce qui se passe à La Haye,
what
à
is
la Cour
taking
pénale
place
internationale.
here and what is taking place in The Hague at the International Court of Justice, and perhaps this is due to the fact that I did not express myself well. I was speaking of a trend. My colleague has repeated on several occasions Duralex, said Lex, and recalled the criteria that applied in law. But this is why I made this clarification discussing trends before occurring in international law. The reason why we make this submission today is that there are fundamental and intrinsic differences between the situation in French, Swiss, or Belgian law, wherever you have municipal law with civil parties, where a crime was committed 6 months, a year, or 2 years ago, countries where it is easy to find material evidence if required, and our field, that of international criminal law, where events occurred in a time of war, where years have passed. And what seems to us interesting in the trends that we see outlined in the International Criminal Court is the fact that even though the International Criminal Court is seized only of situations which have occurred a relatively short time ago because of its statute, even with those specificities, what we see outlined as trend, as general tendencies, is the ability of that court to accept indirect evidence. And this is very interesting because we are here in a similar situation to that of the International Criminal Court. Mention these trends, which, in our opinion and in good faith, support our opinion. And I want to return to a point that is systematically raised by my colleague, which is our position, which is another position, the position according to which our civil parties must have the ability to plead on sentencing. That is a completely different issue. As you know, this is a question that is submitted to the chamber. Our pleadings were submitted in writing. This ruling will come out. This has nothing to do with what we're doing today. It's totally distinct, and I tried to focus my intervention today on what is needed in order to be able to say this person is indeed a civil party and can enjoy these rights. One more point. My dear colleague seems to enjoy Latin, and it is perfectly justified. Juralex sed lex, in fact, applies both in internal rule and elsewhere in general law. There is nothing, in fact, in the internal rules and in the practice directions telling us that our civil parties must come before this chamber with a biography or a confession in hand. So if we wish to apply Juralex sed lex on the basis of the internal rules and on the basis of the practice directions, if they tell you something that is sensible in their applications, then you must admit or accept these applications. Thank you.
Mr. President, I would like to seek your leave to add to what my colleague has just said in relation to the legality and the right of the civil party, so that the Defense Council and the Chamber as a whole can understand the legal right of the civil party to make their application. The Chamber, yes, you are granted, but please limit yourself to the conditions and the criteria of the civil party application. And also you should respond to the challenge raised by the Defense Council. You are not allowed to make your comments or observation at this stage. The Chamber reserves the right to stop you, and without giving you any extra opportunity, if when you speak in general term If the chamber noticed that from the beginning, then you will be interrupted and you will not be granted an opportunity again. The yesterday practice was or should be adhered to today as well. Tisrina, thank you, Mr. President, for your guidance, and I will try to only raise the relevant evidence and fact. First of all, to my respects to your honors and ladies and gentlemen in the chamber, in response to Mr. Francois Roux, the Defense Counsel, I would like to raise the issue of the legal right of the civil party. The Defense Counsel raised it should be done through the co-prosecutors as the civil parties are in support of the prosecution. I would like to say that this is a mixed tribunal. It means it's a hybrid of national and international court. An agreement was made between the United Nations and the Cambodian government in Article 12. The Cambodian laws are applicable in this chamber. And when I look at the Cambodian law, stipulating the right of the civil party participation in making the application to this chamber in the Code of Criminal Procedure of the Kingdom of Cambodia, it stipulates clearly in Article 13 relating to the civil action. Civil action and damages shall be responded by and shall be actioned by the victims. And who are the victims? Of course, we have some direct victims here, for example, Chum Mei and Bu Meng. That those are the direct victims of Accident 1, and some also provided testimony before this chamber in the previous hearings. So that is the right of the civil party participation in making their civil action and civil claims in response to the damages caused through them. Francois Roux also said the civil action shall be connected to the direct kinship, for instance, between father and son. But in Article 16 of the Code of Criminal Procedure, it states that the successor of the in the case of the death of the victim, a civil action can be started or continued by his successor. And the successor here refers to the natural persons who are related legally in relation to the kinship. For instance, the direct bloodline relatives, father, mother, children, brothers, sisters, siblings, cousins. It means who are the blood relatives to the victims. So those civil parties who lodge their applications in my groups, they are related in some way to the facts and crimes alleged on the accused. So they are entitled by law to make such application. The President, the challenge is regarding, is it regarding the right of the civil party to participate, or is it related to the lack of documents to prove the kinship of the civil party applicants, or the lack of documents to prove that they are the direct victims of Accident 1? And that's the core point of the current proceeding. So your response should be directed to these challenges. you have to consider, are they challenging the application as a civil party participation, or are they challenging the lack of document related to the applicant or the victim of S21 office? So the chamber would like you to remind to only focus on the points raised by the defense counsel. And this is particularly related to the E2/49 or E2/69 or E2/74, what is available and what is not, and E2/75 or E2/73. And you are not allowed to make your general observation, as I reminded you from the beginning. Do you understand? If you understand, the chamber will allow you to proceed. Otherwise, you will not be allowed to proceed. You can reserve all these comments to be made at the final oral submission. Tisrina, Mr. President, yes, I understand your guidance. What I have said is in response to the challenge by the Defense Counsel. The chamber, are you talking on the points raised by the Defense Counsel? If not, you have to be seated. Tisrina, in relation to my client, I would like the President to consider the current situation experienced by my client. And the points I raised is also in response to what has been said by the Defense Counsel in his challenge to the civil party applications in my group. And I based my comment on the existing law of the Kingdom of Cambodia. Thank you, Mr. President. The President, Kasabut, you may proceed. And you are reminded only to express your observation on the challenges of the legality or the qualification of the civil party application, or any related evidence to support that civil party application, and you are not allowed to make your observation or submission in the middle of this proceeding. Thank you, Mr. President. Good morning, Your Honors. Good morning, ladies and gentlemen. As I have stated in my previous observation yesterday, the Defense Counsel only wishes the civil party to verify in their documents, in their application, the qualification as a civil party. For instance, whether they are the husband or the wife or the son or the daughter or the brother or sister. And there are supported documents to prove that. That is the first criterion that the Defense Counsel wants. You show that document, then we will accept it. So that is the first criterion. And the second criterion is the evidence. The evidence that the Defense Counsel wants is whether the civil party applicant actually has a relative who suffered or victimized at S21. If it is clearly shown so, then we will accept all those civil party applications. For instance, this can be proved by a photo with the number from S21 office. And if you don't, and you only show us a photograph from 73 or 72, how can the Defense Counsel accept that? We cannot accept it. And if you cannot find a photograph, then a confession would be sufficient. And if there is no confession, then the list of the prisoners. And there are two lists. One was prepared by the Office of the Co-Prosecutors. And then for the second list, you can go to have a look at the list of the S-21 at the Genocidal Museum. All the lists are maintained there. And then you just photocopy the relevant page with the name. Then the defense counsel would happily accept it. And if you cannot have all these documents, then you have a biography. If you have a biography, then we will accept it as well, a biography from S-21. Or if the biography was used to wrap the fried banana, then probably try to find anything else, like a photograph from S-21. Thank you. The chamber, the president. Let me now stop the discussion and the adversarial hearing on this civil party application. The International Co-Prosecutor, do you have anything to add?
Thank you, Mr. President. I wish very briefly to return to the general observations we made yesterday concerning the flexibility which we feel should be applied in consideration of elements of evidence that are produced by civil parties in support of their applications. However, there is something which I find disturbing in the debate which has just taken place. In fact, 2 points. First of all, the fact that the defense returns to the role of civil parties. It seems to me that within a few minutes we will be having a debate concerning the role of civil parties. And apparently we are not allowed to respond to this at this point.
The President, the chamber now will not allow any adversarial hearing or discussion on this matter, on the challenges and the responses. I just said that. The President, the chamber would love to move to the new section, that is, a brief submission shall be made regarding whether the civil parties are entitled to put questions to the accused regarding the accused character. The co-prosecutors now are given the opportunity to make their observations regarding this subject, and you have 10 minutes to do so. Mr. Hong Kam Soon, do you have anything else to add? Hong Kam Soon, thank you, Mr. President. I would like just to take a brief moment of your time. It's not related to the adversarial hearing regarding the civil party application. One civil party applicant, E2/32, who made a statement on the 9th of July 2009, and this civil party did not fully provide the information to the chamber, and on the 10th, for the E2/32, I wanted this civil party to show the statement regarding to a guard at the Tulsline prison, and this civil party was so moved by the countering with the former guard.
Mr. Kum Soon, I only refer to this person with the court name because it is still confidential. The president interrupts. Could you please tell the court what is exactly your purpose of standing up and raising this matter? Because we are ambivalent as to whether what kind of submission you would prefer. But please be brief and summarize your point so that your point can be well communicated to the audience. And if you cannot do that, then the small problem becomes bigger. Mr. Kumthun, thank you, Mr. President. I will rephrasing my remark, and since I have already been notified that this is the last moment for raising any matter in relation to the civil party matters. I have a civil party who is my client, and during this moment, he would like to submit a new application to be filed in the case file, especially in relation to the matter of S21. The reason behind this is that this document was not presented on the 9th of July 2009 regarding the suffering he experienced during the time he was detained because he was acquainted to another guard who was also at S21. So my request is that the civil party is allowed to submit additional facts in relation to the mistreatment he received by the guard at S21. So he would like to preserve his dignity, and that if the chamber allows, it would be very grateful for him. The President, Mr. Hong Kum Soon, I think probably my capacity to understand you is very low now because I seem to understand nothing from what you have said, and I believe that my international colleague would share the same problem because we just don't understand what you are talking about. Please tell everything you want to say. I don't know what exactly would it be. So what kind of fact are you introducing here? Is it a new fact? If it is new, it cannot be introduced now because the chamber is now hearing the facts that have already been alleged and laid out in the indictment. So further facts are not related to this matter before the chamber. So according to our Criminal Procedural Code of Cambodia and the internal rules, which are very harmonized, I believe that we are not dealing with the new facts now at this moment. So it would be best if you can now please rephrase your statement in a more concise way. Mr. Kumsun, thank you, Mr. President. I may now proceed to clarify the position. My client is a female civil party, The president interrupts. Of course, the civil party, but please use the pseudonym. I know that it is very confidential, but please use the pseudonym of that person. Mr. Hong Kum Soon, thank you, Mr. President. I'm talking to the civil party E2/32. And I'm not saying the full name of this witness who actually who was the former staff of S21, and it is not really a new fact, but the problem is that the civil party failed to tell the court that she was tortured and raped. So this is the fact that we would like the chamber to also admit this fact that the person failed to include in her testimony before the court on the 9th of July 2009, and that this person would like to add that she was also raped apart from being tortured. The President, you said that there is another witness who will be supporting E2/32 in relation to her attempted fact. So then if there is another witness, then we have to really deal with the witness on top of the civil party that you mentioned, and whether this application is admissible or not. Mr. Hong Kum Soon, thank you, Mr. President. That's why I put this matter before the chamber. I would like to seek permission or a consideration of the chamber to accept the E2/32 ground that she was raped.
Et prennent en compte le fait que E2/32 a été victime d'un viol.
The President, Chacha Lavigne, you take the floor.
Judge Laverne, I'm going to try to clarify things a little bit here. I thought I understood that the origin of the issues that we're dealing with today is to determine if your client's civil party application is admissible, or is this something completely different we're talking about? Because I understood at one point that you are asking that we summons a witness again so that he can establish that the client was detained at S21, or are we trying to bring up facts that have not yet been brought up at all yet, and that do not stem neither from the hearings nor from the closing order?
Mr. Hong Kum Soon, thank you, Mr. President. I would like to add further that this fact is related to and this request is made in relation to the request made by lawyer Silke Studzinski. The request has already been made, although I don't remember the ER number of the request, and I just would like to make it clear that it is the last moment that we have to address the matter of the civil party matter, because my client said that the guard at S21 raped her, but she was feeling embarrassed or shy to actually tell the court whether she was raped at the moment when she was giving the opportunity to testify before the court. So I'm asking whether the chamber would consider calling that witness to give testimony. before the chamber or not.
C'est la raison pour laquelle nous voulions vous communiquer ces informations.
The President, it is now an appropriate time to take the adjournment, so we'll take the adjournment for 20 minutes and we resume at 11 a.m.
សូមអញ្ជើញក្រោកឈរ
La greffière, veuillez vous lever.
The President, please be seated. The court is now back in session. The chamber is now going to pronounce the decision after having heard the parties on the question raised this morning, which was, are civil parties allowed to question the accused and the witnesses called to testify at the part of the hearing that is entitled, according to the scheduling order, the chamber decides by majority, Judge Lavergne dissenting as follows. Civil parties are not allowed to ask questions to the accused relevant to the character and to the following witnesses appearing under the following pseudonyms or names: KW34 and Francois Zironi Gilbo, D1, D2, D3, D4, D5, D6, Christopher Lapelle, D8, and D14. The written decision, including the reasons of the majority and the minority, will be issued in due course. The time allocation for the co-prosecutors and the defense to question the accused on his character will be 1 hour and 15 minutes each. The parties will be informed of the time allocation for specific witnesses next week, which is Monday next week. The chamber will now proceed to hear the questionings and responses in relation to the character of the accused. The security personnel are now instructed to take the accused to the dock. The President, we note that Mr. François Roux is on his feet. You may proceed.
Merci, Monsieur le Président.
François Roux. Thank you, Mr. President. At this stage, the defense wishes to ask the chamber that it read out the paragraphs in the indictment regarding what has been titled as personality elements. That is to say, paragraphs 162 to the end of this order. And I'd like to remind you that at the beginning of this trial, when the greffier read out the indictment, the defense asked that the paragraphs regarding personality also be read out, and the chamber answered that this would be done when this issue of personality is brought up. So therefore now, as we're going to be dealing with this question of personality, it would be suited to read out the appropriate paragraphs.
The President, the chamber now accept the request by the defense counsel. The greffier, Saikolwati, is now instructed to read part of the closing order by the co-investigating judges from paragraph 162 to 170.
The graphic. Part 3, character information. A. Early life. Paragraph 162. Duch was born on 17 November 1942 in Pawai village, Pimbang sub-district, Stone district in Kampong Thom province. His father deceased in 1990 and his mother still living. They were poor peasants of Chinese origin. Duch appears in the register of birth under the name Kaing Guek when he was 2 or 3 months old. His name was changed to Yum Jiu under the advice of a fortune teller. Since he did not like this name at the age of 15, he asked his father to change it again. He took this opportunity to modify his date of birth to appear younger in order to register for school. Henceforth, his new identity would be Kaing Guek Eav, born on the 15th of February 1945. During the Khmer Rouge period, he assumed and was referred to by his alias, Duch. However, when he lived in China from late 1986 to July 1989, he asked to be called Hong Pen. Paragraph 163. Duch was the eldest of 5 children and the only son. He got on well with his parents and sisters. He often appears to have been ill when he was small, with what he called illnesses caused by poverty and living in the countryside. He began school late at 9 years of age. A good pupil who simultaneously feared and was fascinated by his teachers, whom he respected highly, he completed his schooling successively at the Kampong Thum Junior High School, followed by high school in Siem Reap, and at Lycée Sisawat in Phnom Penh, where he passed his baccalaureate in 1964.
B. Personal, professional, and political evolution. Paragraph 164. In 1965, Duch was appointed as a mathematics teacher at the junior high school in Skun. His students would later describe him as a sincere, devoted man, always seeking to help the impoverished. This professional activity did not last long. However, as Duch was gradually becoming the revolutionary that he was to remain for more than 20 years. From age 15, he had been attracted by political activism, having felt humiliated when he became conscious of his family social situation, especially when faced with the implacable demands of an unserious uncle. In this respect, he was undoubtedly influenced by several of his teachers who denounced corruption and social injustice, and in particular by one of his instructors, Kaing Guek Eav, who would later be executed at S21. Paragraph 165. Duch's family and emotional life was characterized by great stability, except for amorous disappointment during his youth, which he described as being important. Duch only mentioned one woman in his life, his wife, Chum Sopal, alias Rom, who was a garment maker. He explained that with Son Sen's approval, he had been able to choose his wife, whom he had met in 1974. Duch married her in 1976, when he was already chairman of S21. He would have 4 children, a girl born on the 27th April 1977, a boy born on the 14th of December 1978, another girl born on the 30th of June 1981, and a son born on the 28th of October 1985. Paragraph 166. After the 1979 capitulation, Duch followed in the wake of the Khmer Rouge for more than 10 years. He said he wished to leave the movement, but was incapable of doing so, being a sort of prisoner of the regime in Samlot, where he arrived on the 30th of December 1979. His main task there was teaching. In October 1986, his superior Son Sen, the head of Duch's unit, Office K-18, sent him to China to teach Khmer to Chinese students. He remained there for 2 years and worked under the supervision of Son Sen's wife, Yon Yat. In 1992, after Pol Pot named him to oversee economic issues in Pquam village, Thma Phuoc district, in the province of Bon Tie Mien Chey, Duch lost contact with his commanders. He explained that the rapture was progressive, as Khmer Rouge soldiers dispersed little by little as the war continued. He became a school teacher while trading in rice and breeding pigs. On the 11th of November 1995, in Pquam, he was the victim of a mysterious burglary, in the course of which his wife was killed by a bayonet wound to the chest, whereas he was only slightly injured. In this respect, Duch alluded to a possible assassination attempt financed by Pol Pot. After the death of his wife, Duch started to attend meetings of the Evangelist Church of Battambang. He converted to Christianity in 1996 and has had his children baptized. He then returned to live in Samlot. Yet, during renewed Khmer Rouge combat activities against the government, the sub-district was evacuated and its population crossed over to Thailand. In July 1997, Duch began to work for an NGO called American Refugee Committee, known as ARC, where he remained until his identification by journalists in May 1999. Shortly after that, he was arrested by the Cambodian military authorities. C. Recognition of responsibility. Paragraph 167. Duch has consistently recognized his responsibility for the crimes committed at S-21 under his command. He explained that he was led to speak out in 1999 because it was impossible not tell the truth about S-21. After he heard that Pol Pot denied the existence of S-21 and claimed that it was an invention of the Vietnamese. Duch has regularly expressed remorse to the victims and their families, but also to the S-21 staff under his command. He stated that none of his personnel were volunteers or proud of what they had done, but rather terrorized and constantly in fear for their lives. Paragraph 168. Moreover, Duch has cooperated willingly in the judicial investigation, neither attempting to implicate anyone who was under his orders, nor placing the blame on the upper echelons of the party alone in order to exonerate himself. When confronted with some of the inconsistencies in his testimony before the co-investigating judges, he indicated that they resulted from fear and embarrassment. He felt when reminded of an extremely painful history of crime. Paragraph 169. He noted in his defense, "I joined the Khmer Rouge in order to liberate my people and not to commit crimes. But that from 1971 onwards, when I was forced to supervise M13, I became both an actor in criminal acts and also a hostage of the regime." Duch says that he only became aware of the criminal nature of the regime little by little, beginning when he saw people being evacuated and stripped of their private property, followed by the series of mass executions. He added that when mass arrests were carried out based on Khoi Thuon's declarations, he understood that those who served their own people could be arrested as opponents of the party, explaining that he began to be concerned about and afraid for his life when Nuon Chea arrested Brother Ngat Yu, alias Hong, and So Chea, followed by his superiors like Won Wait. Duch claimed all this led him to be paralyzed by fear for his life, wondering when it would be his turn. He claimed that as time passed, he was less and less able to do his work. turning over all interrogations to hall and simply sitting in the sculpture room, specifying that in the end he was terrified to the point that he slept day and night. Paragraph 170. Duch also claims that, despite many attempts, he never succeeded in escaping from his post, either during the regime or after its fall. He justified this by noting that he was subjected to constant surveillance and that escape would mean death for me and my family. The accused, said the president, can you tell the court about your biography from the day you were born until you were arrested and sent gradually until you reached the detention facility of the ECCC? You can tell the court about your personality, your family, your educational background and relation or social interactions or other matters you believe are important to tell the court. Please be reminded that so far some questions have already been put to you and that you have already stated partially in the proceedings for the last couple of months regarding your character, but they have been part of the normal proceedings in the court, but today it comes to the specific session for the character, the testimony on the character, so that the chamber can take it into account during the time when the verdict is being rendered. So you may now proceed as what has been requested. The accused. Mr. President, before I start to tell the court about my biography, I would like to correct 2 words in this text. First, I went to China and I returned in 1988, in July 1988, not 1989. It was in ERN 212208, paragraph 162. It was actually July 1988, not 1989. And also, I would like to correct another word, which is in the mid of paragraph 165. It was actually the date in 1976, but may I change it to the 20th of December 1975 instead? Next, I would like to now begin with the telling of my biography from the day I was born. I was born in Po Voi. The President interrupts. The accused may be seated since you are going to talk at length, so you are now allowed to be seated, and then you can talk while being seated. The accused, I was born in Po Woi village. It was a village in the jungle, and it was on the river, Stone River, 5 kilometers from Chma River. There was a pagoda in the village, and the pagoda built on an island or a upper ground, on the hill, I may say. My grandfather and the head of the Powai pagoda had been very close to one another, and the head monk of this pagoda treated me as a student.
Five years later, after my birth, my parents had to leave the Powai village, which was the native village of my mother. We go to the Kampong Chen sub-district in Kampong Thom, which was about 2 kilometers from the stone market. The move was due to the insecurity in the Powai village. I was a child who was constantly educated by my grandfather. Even during the time of my study, I was still with him, and I tried to study very hard. In 1955-56, my apology. Cambodia gained independence in 1953, and after independence, the situation in Cambodia became better because at that time, the ransom or the kidnapping dropped dramatically. In 1955-56, I was still in the primary school. I was influenced by two sources. One, from China. All those half Chinese Cambodians in Stone. And there was a rumor that those Chinese people was wealthy due to the indoctrination by the Maoist communism. The Chinese Prime Minister Chu En-lai came to visit Cambodia later on, and that was the influence upon me. The second source of influence was the local, domestic influence. My ancestors always appreciated me that I was a good student, and that when I grow up, then I would not suppress their ignorance or uneducated stance. And also in 1955-56, my teacher, Kaing Guek Eav, gave me some books to read, and the tendencies in the book were in two. One, it was the stance of the opinions of the peasants, like the farmer teacher, the workers, or the driver, and the book on the democracy, and another type of books were by the Free Khmer, Sang Ngok Than, for instance. So my teacher gave me all types of books. Or the Great Thief at the Border by Sang Sawat, De Chu Krohom, also authored by Sang Sawat. Sang Sawat was a colonel during the time. I studied just to gain my knowledge at the time. And when I went to study at Kampong Thom, I kept continuing my research. I read anything I could lay my hands on. And I actually also wanted to know about the religion, and I bought a book of religion by Kaing Guek Eav, who was knowledgeable only in Buddhism and no other religions. I kept studying, and then I realized a study club, never 5 members in there. I myself, Hồ Nghĩa, a Vietnamese child, Cụm Thươn, Khmer, we are 3 males, and Susat and Kun Samut from Trapang Veng, one deceased already in 1968. She went to the forest. She was a party member and she died at the Oural Mountain. And the rest of the club members are still alive. In 1962, there was a rebellious activity at the Lycée Sisowat. I did not join that movement yet at the time, but the movement, the strike and the demonstration were intense at the time. And I still had paid my gratitude to my teacher who protected me at the time. And in 1962, in that same year, I met Son Sen. He called me. He sent somebody to call me to meet me. And then I promised that only after I joined the movement, then I would consider my stance on the revolution and after I passed my final exam. So my knowledge gathering was flowing in, and my decisions to join the revolution was based on 3 parts. One, I actually persuaded one woman to study mathematics with me, but she refused. Second, I went to study arithmetics, and during the time of the study of arithmetics, my bicycle was stolen when I was still in the classroom. And third, the local authority conducted the arrest of those who spread tracts, and they were accused of traitors, and they were alleged of conducting a coup d'etat to overthrow Sihanouk. Chai Kum Ho, who was my educator, was arrested amongst various other people. So, by observing those situations, I made my decision to enter the revolutionary movement. I knew at the time, through my teacher of culture, Khun Man, who told me that the joining of a revolutionary movement was like a spear. Once you come into a spear or a mortar, then you cannot remove yourself from it. And I knew that once I entered, there's no way for me to return. But my belief at that time was intense and was committed, because then the revolution have an option to salvage the country and to rescue the people. I noticed the changes in the entire world. First, it started with the Soviet Union, with Indonesia, who had the majority Muslim people, but overall, it was taken over by communism. At that time, Nasakom was the organization that led Indonesia. Nasakom arrived from Na, means national. Za is an Islamic word, and Kom, that refers to communism. And I became the president of Indonesia. So by observing all those situations and by seeing that even the Islamic community could not stand the force of communism, and only the communism was the waves to override everything else. And that was the reason for my decision to join the revolutionary movement. And when I went to teach, I did not pay much attention to the teacher's wage. My focus was on the progress of the revolutionary affairs to help the poor students. At that time, we were allowed to live in a society that is a communism within a society of pluralism. For example, we gathered all our property. When I received 7,000 reals per month for my wage, I gave 6,000 to Onka, and I only kept 1,000 for my daily expense. I sacrificed everything. I ignored the need of my parents at home. And I was very proud that I sacrificed for the revolution in order to help the Cambodian people and the country. I was at school. My connection was also at school. There were 4 of us. I was at school. Ho Nghĩa at Ong Ta Saum, Ân Lon alias Nad at Kampong Thom, and So Kam An at Kampong Thom. In this network, we call it the Core People Network, and I was the chairman of that network because I was so influenced in theory. But I was not a type of person who did not know anything about theory. The first book of theory that I studied and tried to absorb the knowledge was Principes Élémentaires de la Philo. That is the primary philosophy of communism by Jacques Pulitzer, who published a lot of books on socialism. I tried to study that book very hard, and later on, I read books by Mao Zedong. So that was my way of trying to understand the theory. And my feeling was attached to it. And I remember one phrase by Mao Zedong. He said, the true love for the people is to give an absolute authoritarianism to a party. And in a new democratic society, we have to be absolute on the robbers, the thieves, on the people who commit larcenies. And I reflected on this theory. I thought, well, it's one of a good type. So for an authoritarian regime, everything has to be absolute. It meant there had to be a total elimination of those bad people, like the robbers, for instance. At the end of his book, Mao Zedong said, allow the blossom of the 1,000 types of flowers and allow the 100 theories of politics to compete each other. I was so satisfied with that phrase. And when I looked at the discipline of the Buddhism, I was also satisfied. It means we do not have to revenge one another. But I think it's impossible. And in the Christian religion or discipline at the time, although my knowledge was limited, if you are slapped on the left, then you give your right cheek for another slap. And I don't think it's possible to serve the people with such a theory. So I still made myself involved in the movement. And on the 29th October 1969, the party assigned me to go to settle in the forest, and there was someone who took me from Phnom Penh to the forest. I met Koi Thuon at the Kampong Thom, and at that time the messenger network was cut off in Croce, and then Koi Thuon transferred me to live at Chamkale with Kai Pok. A few days later, I was arrested by the government and imprisoned. And even if when I was imprisoned, I struggled from inside the prison, although it was not as effective as campaign. And after I was released, I still continued to make my movement. And in August 1970, I left Phnom Penh to the liberated zone in Saang Koh Thom. That was the time I observed a peculiar situation in resolving the conflict by the party. It was the conflict between the Communist Party and the Workers' Party of Vietnam. The Vietnam's party assigns their force to come to administer the local authorities and establish their organization in Saang Koh Thom, and it was called Sector 62. And the An Giang province was the authority to organize such administration at that level. One Khmer Kraum Chau Kaim, who was a party member of the Workers' Party of Vietnam, came to join the Communist Party of Cambodia. And people were shot. Another person was also shot, who was a tax collector. So I observed the conflict between Cambodian and Vietnamese. It was not on the stance of comrade to comrade, fighting together, shoulder to shoulder against the imperialists, the US imperialists, no. But they were superior than the Communist Party. And also during that time, people from the East Zone organized Sector 25 with Chau So Wan as the secretary and Sok Bot Chamran as the deputy. This Sok Bot Chamran had the original name of Moni. And after a while working together with him, he was arrested. And our force from Phnom Penh, one of us was killed, and 2 or 3 of us were arrested and imprisoned. And Chau Chat fled to meet Von Wait. And Sisawat, alias Chamran, intercepted and arrested him. So I saw the intense conflict within the party, and a police force was established by Mang Sam Nang, alias Teng, and I thought that if the leader was like that, then the police office which was established would be eliminated. I lived under the protection of a cadre from Hanoi named Sing San. The person was the general staff of the sector. And until May 1971, I fled that area to meet with Von Wait. I remember that the police in the Khmer Rouge style would be in the same fashion as the Khmer from the Israel era. It means they would be killed soon. When I arrived, I was asked to attend a training south of the Piem village in Kampong Trolai district. After that training, and on the 20th of July 1970, Brother Hock came me to work at the police office. I begged him not to go there because I believe it's going to be eliminated. Because if the chief of the police betrays, then the subordinates would be eliminated as well. But Brother Hock insisted that no, the decision was made from the Central Committee, and you wouldn't have no authority to make any arrest or to make any request for the arrest. You you were only assigned to interrogate, and then later on you might be assigned to smash people. And I told Brother Hock that I would not be able to smash anyone. I begged him, and later on, I was assigned to be the chairman of the police office, and the smashing was their responsibility, and the police at the M13 was organized by them. At that time, people were sent in, and I did not dare to kill anyone. So the number of the detainees keep increasing, like Bizo stated, because I did not dare to kill any of them. And that was the time I requested to create another M13B in order to receive those people, those incoming people. And in 1973, those people who I gathered in order to work with me, they rebelled and they took some guns and fled. And I believe that would be the best opportunity for me to remove myself. And then I went to appeal to Von Wade that I made a mistake, and then that there was a rebellion and some of the comrades were injured, and that would have a bad impact on the party, and that I was responsible and that I should be sanctioned or disciplined. But he did not look at my face. He was speechless. He didn't say anything. Then I said goodbye to him. And later on, some people were still sent in to be interrogated. And I thought probably that would be my fate. I was still thinking of the fate. And I also thought of the poem that I learned. So if that's what my fate was, and that I could not avoid it, then I would just have to carry on with the assigned task. And that was the time I saw the authoritarian view of the party. I recalled the theory of the teacher Promans that once you are into the circle, you cannot remove yourself while it's in motion. And I believed once the independence was gained, then I would be asked to be transferred to be a teacher again. That was my thinking. I fulfilled my duty, but at the same time I was shocked of what happened. And at that time, cooperatives were started to be established. And the direction for its establishment was not to allow the Vietnamese soldiers to buy rice from people at their own will, and that the rice should be kept for the supplies to our soldiers. And if they want to buy for rice, then they have to go through the Communist Party of Cambodia. But actually, the percent was for Pol Pot to have an overall control of the forces within the communities, within the cooperatives, through meetings, through monitoring, so that they have a full grasp of the total quality of rice at every cooperative. Also in the studying materials and documents, which has a character of fascism and authoritarian, as shown in the Revolutionary Flag magazine. It reads, whatever lines for the source for the social stance, then the view and the stance has to be for that class. And what is the class and the party line? The line was the workers' line. So if you are not in the workers' line, then you cannot be a member of the workers' line, and that you cannot carry out the duties of the workers' line. And if you cannot be in such a land, then you would be removed. So that study would force people to make themselves to be part of the workers' line. And this is simply to work because otherwise you would be killed. And yes, indeed, people were killed. Intellectuals who sacrificed to work in the countryside, who were in similar age to mine, were arrested. Aurai, for instance, who was an author, he only studied up to the diploma certificate. He was arrested at the Kampong Sela school for no clear reason. So if you did not do what you were asked, you would be arrested. Song Ha Hyun, the subordinate of Tam Mok, was also arrested and sent to M13. And that what I witnessed personally. The Hanoi cadres were arrested and also sent to M13. There were a handful of them. So if I did not follow them, I would be arrested as well. I strived to work hard, and I was in constant fear in order to survive to see my parents. So my purpose of liberating the people was instead to be part of a mechanism to killing people. And after the 17th April 75, I took the opportunity to meet Kaing On while he was gathering workers, and he said, yes, I wanted you to work for me, and I would inform you later when I come next time. But on the 31st of May 75, I went to wait for him. He never turned up. I said, that will be the end of me. And on the 20th of June 75, I was called to study. After that study session, I met with the teacher. Then I returned to Om Leang. And on the 15th of August 1975, he made a presentation on the establishment of S21. At that time, Nat became the chairman and I was the deputy, and I was rather relieved because I believed that the majority of the decisions will be made by the chairman. But then in March, Nat was removed and I was assigned to replace him. I could not protest, so I became further involved in that circle in motion of the mechanism. I knew I fell into the criminal mechanism and that I could not remove myself from it. From 69, I fled because I was led by the party line, by those who were involved with the party. But now the CPK constantly supervising me, and what could I say? I could not remove myself from this circle. Therefore, wanting it or not, I had to fulfill my assigned duty. My knowledge in theory was also one of the quality that satisfy them and that makes the subordinates appreciate my role and performance. And in the final plan, as mentioned by David Chandler, I myself, I believed I built people based on my conviction and commitment, and probably only 10 good people were built by me, because the extent and the scale of the crimes committed by the CPK was so wide, and my ability, my capacity was so minimal, was negligible, and that I could not achieve anything else in order to amplify my qualification.
Number 2. I was a very strict student, meticulous. So it was a kind of incentive and good qualification if this can be interpreted in my honesty in the party. However, if it can interpret it in the way that crimes is committed, then it would be a part of the very horrendous crime committed by doing that. Number 3, actually, I know that the confessions and my superior, Mr. Son Sen, did not even believe that the confessions were true. But still, we wanted to obtain confessions. So they are part of the crimes committed at S21, and all the crimes committed at S21 were under my complete supervision. And when people talked about foreigner being burned alive, I was expecting to hear and to challenge the person who actually told the court about a person being burned alive. And after all, as I indicated clearly, no one could violate my policy or order. I did not really talk strongly to my subordinates. However, everyone had to respect my orders. My subordinates could pay a visit to their families, but I did not really have that opportunity to pay a visit to my parents. During mealtime, I would be joining them, but Ho was in favor of me, that he gave me the dry meal or the dry food on top of what the other people could have. And I may not tell the court more than that, and I would like to leave the floor open for the chamber to put more questions for further clarification if the chamber so wishes. Thank you. The President, when you decided to change the name, you used the name Duch to replace your original name, because at the beginning you were called Kaing Guek Eav. Can you tell the court when exactly did you change your name, and what would have been the reason behind the changing of name? Response. Mr. President, in 1964, I joined the revolution. At that time, my name remained unchanged. But in 1967, there was a secret session held. The location of the session was to the house near the Maha Montray Pagoda. And at that moment that everyone's name had to be changed to the revolutionary name. My name was changed to Duch, Chai Kum Ho changed to Hok, Nong Sarum changed to Sang, So Kum An changed to another name, while in Lon was changed to Nat, so on and so forth. And why I chose Duch, I think I made it clear before the court already, because I would prefer a Cambodian name. I didn't like Chinese name, because I remember the last message left from my grandfather, because at that location there was a Buddha statue that was really carved by the artist grandfather Duch, who was very good at carving the Buddha statue. That's why I prefer the name. And there was a situation when there was a person named Duch who was asked by the teacher to read a book, and Duch was really a good student who was very obedient and loved by the teacher. So that's why I preferred the name, because I thought it was really the Khmer name and good name. The President, we have already studied several documents, and through the debates we have observed that you used the name Duch for quite a long time. But can you tell the court whether you also have the surname for Duch, or was it required by the revolution that people used only just one word other than having the first surname or family name? Response. Mr. President, at M13, it was the secret office, so was the S21. My name would not be revealed publicly in the party, so it was used secretly. So I used Duch alone, and I could not really use my family name Kaing before Duch. So normally it would be obvious that people would know who the person was, so Duch would be sufficient enough to keep the secret. The President, the reasons you changed your name from Kaing Guek Eav to the one word Duch, besides the secret purpose for the confidentiality within the party, was it supposed to be serving other purposes? Response. There are two reasons. First, it's for the revolution. Number two, it is the Khmerization, or to make sure that I really use the real Khmer name for my name. The President, in your statement that you made just now, you showed your social status and involvement, and after you graduated with a degree in teaching and you taught at the Skun Lycée, you said you did not pay great attention to the benefit from your profession as a teacher, because you indicated that you devoted great proportion of your salary to help the poor students and the other poor teachers. Can you tell the court what kind of activities you had done to manage your salary, and to what extent was your salary be used to sponsor those poor people? Please give us some example of how your salary was managed. Response. In helping the poor students, actually I chose a few students and I raised them. Then there was a brother of Nat also among them, and I had to cover their meals, and I have to organize a student cooperative, what I call, and we bought things from Phnom Penh to be sold for the students, and we bought at a higher price but sold at a lower price, and I covered the losses, and we did not make any profits, but we made profit only from supporting the students. And at the school, there was a school which was going bankrupt, or maybe the situation was deteriorating, and teachers were not really well paid, so I could help them by sharing my salary to substitute the very minimal wages of those teachers. And later on, the situation was improved and it was supported, and that later on I could manage to save some of the salary I earned or made from my teaching career. And I helped 2 people at Skun, but they died already, but I don't want to reveal their names before the chamber. And this is how my salary was managed. And as I informed the court already, that I did not really manage some money to support my parents, but instead support the poor. The President, you had already described or explained to the court significantly. However, there are still some thing else that the court would like to know, because after 1979, after you were arrested by the authority in at a later date, but could you please tell the court what had you been doing after 1979 until the day you were arrested and detained at the military court before you were sent to the detention facility of the ECCC? So please just briefly tell the court your roles on what had you been doing from 1979 until the day you were arrested by the Cambodian authority, but we would be interested to hear only your involvement in the Khmer Rouge forces. Response. As I already indicated before, after the 7th of January 1979, unconsciously, at about 11, I was about to have my meal. Then I spotted the tank, and I asked people not to eat their meal, and I asked them to wait orders. I went home and grabbed a pistol and came back. I did not even manage to wear my shoes. I could not even get my pens, so I could get only the pistol and shorts. And at 2 p.m. we reached Son Sam Koksal Pagoda. We didn't sleep for 2 days. We didn't have any food or water. And whatever people did, I didn't care. I only made myself to sleep and gain some strength. At that time, Mok was appointed as the chief of the West Zone on top of the Southwest Zone. And he demanded that the combatants or the soldiers were dispatched to him. But Ho and other people did not want the soldiers to be dispatched to Tamok, and they intended to fight to the last minute. And a few moments later, I ran to Liang, and Tamok ordered Brother Pal to really give all the soldiers under my supervision to him. And then I managed to really gather those soldiers and dispatch them to be under control of Tamok. Later on, we kept running until we reached the the northwest zone, so that we could really get some rice to feed on. Brother Sarun later on became the secretary of the Northwest. And it was the moment that my former soldiers and forces in my unit started to die and separated. So a lot of people died, including my in-laws and nieces and nephews. Finally, it was I alone and my wife and 2 children, and we went to Samlot, very lonely. On the 30th, I asked Brother Sarun so that I could go and work with Sumet. I was allowed to do so. But when I was about to move already, I was asked to come back. And we could not move further anyway. After all, I ended up being with Sumet. And I was waiting for my brothers and relatives, but after all, I learned that they all died. I had been with Sumet for some more months. After about 12 months, or maybe less than a month, then Sumet assigned me to be the chief of the transportation. And he wanted me to be the commander of Division 75, but I did not want to receive the offer. Sumet was rather upset because I turned down his offer, but I didn't care. Later on, Sumet asked me to, or called me to a meeting, and I was warned by him. And he asked me to teach his children. I taught his children and my children. About 1 year, Son Sen asked me to meet him on the 25th of June, 1986. I went there with Sumet, Brother Tet, So 3 of us went there. We were put to wait by the receptionist, and they asked us to wait for uncle. I did not know who uncle it was. Then Son Sen appeared, and I saw him. And then he asked my name, and then I told him that my name was Pun. It was the time when I changed Duch to Pun. On the 26th of June, I met him. On September, I was asked by him to go to China to teach Khmer to students there. I only came back in 1988. And I still worked as the person who wrote curriculums and under the supervision of Son Sen's wife. And later on, I was assigned to be in charge of economic section at Guam. And then there was a fighting in Duch, and we lost contact with the party. And then I joined this educational institution, becoming a teacher. Then there was an integration, and Ieng Sari defected first. Later on, Son Sen also surrendered, and my children went to their aunties, and at that time, Mia Mut, under the supervision of Tamok, evacuated people to the refugee camps. And I then worked for the American refugee organization called ARC. Then there was a repatriation process. Then we came back, and I was met by journalists, including Nick Dunlap. And later, I was arrested and detained at the military court. I was detained by the military court on the 8th of May 1999. And I reported about this already to the investigating judges of the military court, the full account of my work until the day I was arrested by the court, the military court. The President, thank you. Since it is now an appropriate time to take the adjournment, we will take the adjournment now. The chamber will resume on the 31st of August 2009 at 9 a.m., which is next week. On Monday, the chamber is going to hear the testimony of 2 experts. And as scheduled, we're going to hear these 2 experts for 1 day, for 1 full day and a half day. Mr. Francois Roux, I note you on your feet. You may proceed.
Oui, Monsieur le Président.
Yes, Mr. President, 2 points before we adjourn. The first, we would like to inform the chamber that the defense waives the hearing of witness D14. So I would like the chamber to know this as of now. So D14 will not come. And another point is, could the parties be informed as soon as possible of the schedule that the chamber wishes to set up, in particular for the pleadings.
Je vous remercie.
Thank you.
The President, the Chamber has already informed recently, since there has been a little bit change, the Chamber waits to see how we can calculate the appropriate time to be allocated to the parties. But this calculation of time will be notified to the parties on Monday. So parties will then be informed on how much time would be granted to them to question the the expert witnesses, and because the chamber will also make a decision to calculate this time as to which expert witnesses would be put question by the party, especially the civil party. So I think the time allocation will be different. So we will inform the party on Monday about this time allocation to put questions to the witnesses. The President, do I make myself clear? If you don't understand, you may ask Mr. Kasawut, who is quite familiar with my message. The court official, could you please check whether translation is not true or is it true?
Monsieur le Président.
Mr. President, I believe that my esteemed colleague, Mr. Roux, is asking and wanted to ask that we understand that you're going to come very quickly with an indication in terms of time allotted to each party, and I think that what Mr. Roux was asking in regard to that, because many of us are going to have to leave Cambodia as of September, and I know that you're working on this, but it would really help us a lot if you could tell us as soon as possible when we are supposed to return in October. And I believe that that is what Mr. Roux was asking, and I am on my feet because I fully support his request.
The President, the Chamber has tried very hard during the last few days due to this necessity. That's why sometimes we had to postpone the hearing in order to discuss those urgent issues. And from my recollection, we agreed yesterday already and I, as the President of the Chamber, have already signed that document, and it has been emailed to parties to the proceedings. You should check your email.
Mr. Dismail. Mr. President, another question just to clarify regarding Monday and Tuesday's hearing. You spoke indeed about questioning two expert witnesses. I would like to know if they're going to be questioned together or successfully, and also successively, corrects the interpreter, and how much time will be given to the parties to put questions to them. Thank you.
The President, the Chamber has also considered this matter extensively, but the Chamber has not received any clear information yet regarding the true expert testimony. It is also depends on their choice, so how they want to provide their testimony, either jointly or individually. If they do it together, then the reports will be unified. Otherwise, it's going to be an individual report, and it's going to be repetitious. So the Chamber would like to give the opportunity to get further information from the true experts regarding their testimony and their choice, or whether they have any specific request in providing their testimony, and then the Chamber will consider that request, and the time allocation will be provided to parties to the proceedings tomorrow by email, so that you have the ability to have ample time to make your questions ready for the true experts. For other various issues, and we have already reserved the time. And for instance, in the case that the Defense Counsel waived the right to hear the testimony of the 14, then we could use that allocated time for something else, for our proceedings. So then the schedule cannot be fixed. It will adapt itself to the actual situation, and the legal officers of the Chamber will contact and make the arrangement for any precise information regarding the testimony of the two experts, whether they want to provide their testimony jointly or individually. And we will inform you later on in due course. They have provided certain information, but the information provided so far is not yet complete. And the Chamber will try its best to find solution to this issue. The President, the security guard, take the accused back to the detention facility and bring him back to the Chamber on Monday morning next week before 9 a.m. The hearing is now adjourned.
D'ici 9 heures lundi matin. L'audience est levée.
The chamber, please be seated. The chamber is now back in session. First, the chamber would like to inquire with the Council Hong Kum Soon regarding his intention and submission as he made before the break to make it really clear if the chamber is requested to call the civil party E2/32 to have her testimony heard again before this chamber on the new fact which was not questioned before, that is, the sexual rape by the former guard of S21 office, and whether the request was for the chamber to conduct an in-camera hearing or the request was for the submission of a statement to such effect in writing, so that the chamber can examine and make a decision accordingly. You have to explicitly state your intention, as judges of the bench had different views on what you raised before the break. Hong Kum Soon, thank you, Mr. President. Before the break, I submitted before you and judges of the bench, and during the break, I consulted with my client E2/32 to reiterate her position, and she would like to confirm that she would like to submit her written statement before the chamber of what she had not mentioned in her previous testimony, and that the chamber is not seized to conduct another hearing regarding the new fact. So in summary, she would like me as a counsel to submit her written statement before the chamber. Thank you.
Pour résumer les choses, mon client m'a indiqué qu'elle souhaitait faire une déclaration ou une déposition par écrit.
The President, the co-prosecutors, do you wish to make any observation regarding the request by Mr. Hong Kam-soon?
S'agissant de la demande de Maître Aung Soon.
Mr. President, we have no particular observations to make. We wish only to note that the rules of evidence that we work under, Rule 87, must of course be fulfilled in order to be able to go forward on this request. A priori, we feel that this request is justified and useful in order to arrive at the truth. I hope that the civil party, if it is authorized to make a written statement, that the civil party will be able to explain in what way the testimony or the evidence that she wishes to bring forward was not available at the time of the hearing. And I believe that these motivations must exist and that they need to be explained in the submission. Thank you.
The President, the Defense Counsel, do you have any observation to make regarding the request by Counsel Hong Kam-soon?
De Maître Aung Kim-soon.
Merci, Monsieur le Président.
Thank you, Mr. President.
Je rappelle tout d'abord
I would first like to recall that this is the case of a civil party, 32, that was challenged by the defense because this civil party stated that she had been a staff member at S21, and the defense questioned the fact that she had been a member of the staff of S21. And I remind you that my colleague asked that a witness be brought forward who himself said that that person was not a member of S21 staff. Must we cover all this ground again? Now, I hear the prosecutor telling me that we should be able to authorize the request because the evidence was not available at the time of the hearing. But this is not what is being sought. The request of my colleague this morning is the following. My civil party client did not dare to tell the chamber when she testified, did not dare to tell some of the facts. So I respect the fact that she did not dare to speak out, but that person is a civil party. She is supported by expert counsel. It was simple enough for her at the time to contact counsel to tell them, I can't bring myself to say this to the chamber. And the counsel would have then requested that the hearing be continued in camera. But we are at the end of the discussion of the facts now. And we would accept that a witness return, or rather a civil party, in fact, return to tell us, well, there is something that I hadn't told you before. Mr. President, distinguished members of the court, if you open that possibility, you won't get one person speaking, you'll get a whole queue of people coming back to say, well, there's something we had omitted or forgotten to say, and we would like to say it now. So we are dealing with persons who have legal counsel. When the problem occurred, there was a possibility for them to consult with counsel, and counsel would have immediately seized the chamber. I believe that this is a tardy request, particularly since it regards a person whose presence at S21 was challenged and continues to be questioned. Thank you.
The President. Mr. Hong Kom Soon, do you have anything else to add? Hong Kom Soon, Mr. President, with your leave, if I am not mistaken, I clearly stated that the former guard of S21 who was a witness through this chamber was seen by my client, so it is up to the chamber's discretion to make such a decision. The President, the chamber carefully listened to your request and the observation of the co-prosecutors and the defense counsel, and the chamber will take the request into consideration and discuss, and you will be notified at a later stage. The President, before the chamber gives the floor to the co-prosecutor, the chamber would like to make an oral decision. The trial chamber hereby pronounces orally the operative part of its decision on the following request. Groups 1 and 2 civil parties co-lawyers joint request for a ruling on the standing of civil party lawyers to make submission on sentencing. Document E72 filed on 9 June 2009. The operative part of the decision taken in accordance with Article 14(1)(a) new of the ECCC law is the following. The trial chamber, by majority, Judge Lavange partly dissenting, issues the following decision. 1. The joint request by the civil party co-lawyers of Groups 1 and 2 is rejected. 2. The civil parties are directed not to make submissions relevant to sentencing, including A. Submissions on a sentence to be imposed, B. Legal submissions relevant to sentencing, and C. Submissions on or an evaluation of factors underlying a decision on sentencing. They are permitted to refer to such factors only when they also refer to the guilt or innocence of the accused or a claim of the civil party in question for reparations. The written decision, including the reasons of the majority and the minority, will be issued in due course. Secondly, bearing in mind the decision just pronounced, the Chamber directs hereby the parties to provide arguments in response to the following question. Are civil parties allowed to question the accused and the witnesses called to testify at the part of the hearing that is entitled According to the scheduling order of the trial chamber of 14 August 2009, questioning the witnesses and experts on the issues relating to the character of the accused. Such arguments of the civil parties, the co-prosecutors, and the defense will be heard today. After hearing the defense and the civil party lawyers on the civil party claims. Now the chamber would like to give the floor to the co-prosecutors to make their submission in relation to the question whether the civil parties have a right to ask questions to the accused and the witnesses on the character. The co-prosecutors have a 10-minute time allocation. Co-prosecutors, thank you, Mr. President. On the question whether the civil party lawyers are allowed to question the accused or the witnesses or the experts regarding the accused's character, the prosecution would like to make the following observation. Following Rule 23 of the Internal Rule, which states that in 23(1)(a), the participation in the criminal proceedings against those responsible under the jurisdiction of the extraordinary chambers in support of the prosecution. And 23(6)(a) stipulates that when joined as a civil party, the victim becomes a party to the criminal proceedings. And especially, Rule 94 of the internal rules clearly stipulates that the civil parties are allowed to make the final submission. Therefore, for us to have sufficient grounds and for the civil party councils to make their final submission as stipulated in the internal rules and as directed by the President just then regarding the guilt of the accused, the civil party council shall have the opportunity to ask such question. Also, in our proceedings so far, the civil party council has been granted the opportunity to participate in every stage of the proceedings, and there is no rule which prohibits the civil party or their counsel to question in the proceedings. Therefore, the prosecution has the view that it is appropriate to grant the opportunity to the civil party council to continue their questioning as has been practiced before this chamber. And my international colleague will provide further observation on behalf of the prosecution. The chamber, the international co-prosecutor, you may proceed.
Co-prosecutor. Thank you, Mr. President. Given the fact that we have very little time, I will limit my comments to some general observations that go to consistency and logic. However, it is possible that I may speak longer than 1 or 2 minutes. I do not wish to plagiarize Council François Roux, but yesterday morning he launched into a tirade, the substance of which I would like to summarize here. He stated that this was the first international tribunal or hybrid tribunal to accept civil parties, that this was a genuine step forward after 15 years of struggle. And unless I'm mistaken, he also went on to say that one should not spoil or cancel out all the efforts that had been made. This was in a different context. That's when it was said, that's true. But he did say that this represented considerable progress in the field of criminal justice, and that therefore we were all bound to achieve excellence. Well, today we feel that the defense would need to come up with arguments that are compatible with that statement. For reasons of consistency and because this argument is supported by law, we are of the opinion that the right of civil parties to take part in the debate and the examination of witnesses before this chamber must be guaranteed and preserved or safeguarded. The victims that applied as civil parties are, as is stated in Rules 23.1 and 23.6, parties to the criminal proceedings. That is the general principle. So it has to be one thing or the other. Either we are party to the trial and all of the consequences must be drawn from that, or we are not parties to the trial. In the internal rules, no distinction is made that could justify the fact that the civil parties were as it may be, discounted or second-rate parties. For instance, with regard to the right of appeal, this is explicitly stated in the internal rules, and one cannot conclude from this that the civil parties are prevented from asking questions from certain witnesses. Whether they be character or personality witnesses changes nothing to the rule. Rule 91 with regard to the hearing of witnesses, in fact, makes no distinction between the parties, and there is nothing there to justify a limit being introduced at this stage. Indeed, and returning to the tirade of Council Roux, this is the first time that victims can take an active part in the proceedings and the entirety of proceedings before an internationalized tribunal. And until now, in fact, they have been able to do so at all stages of the proceedings. Some applied before the investigating judge, and they were authorized through counsel, authorized to participate actively in the preliminary chamber on issues of provisional detention. Others applied to the chamber after the order of indictment had been handed down, and each have been authorized to speak in the proceedings. And since this chamber respects the adversarial principle, all the parties were allowed to express their arguments in law, and in fact, all parties were authorized to ask questions from all experts, all witnesses who came successively at the bar concerning M13, S21, Chen Ek, and S24. All of the parties were also invited by the chamber to ask questions from the civil parties, whether they be survivors of S21 and its annexes, or whether they be relatives of persons who had been smashed, and more particularly with regard to the suffering they endured. Thus, on behalf of the same rationale and the principle of adversarial debate, we feel that all parties with no discrimination or differentiation should be allowed to ask their questions of the accused and witnesses with regard to the character of the accused. This is both useful and necessary for the truth to out, and it does not infringe either the rights of the defense or the discretionary power of this chamber. It is not justified that civil parties be suddenly silenced because their voice and their perspective, which is distinct from that of the prosecution, contrary to what Maître Roux said, their voice is an essential voice when witnesses will come before us to speak on forgiveness or reconciliation, for instance. If we cannot hear the civil parties at that time, I believe that we will be making a mistake. The witnesses we will be hearing now are not exclusively witnesses for the defense. They are witnesses called to the bar by decision of the chamber, and they are in no way different from the others. And in reality, this testimony and testimony already heard, as well as the statements of the civil parties, will all, in the end, help you and assist you as judges to make a determination with regard both to the guilt of the accused and the level of the sentence. And all those who will testify will not be speaking exclusively on the character of the accused, and they will all have an input enabling you to determine what are the criminal facts, the mode of participation in criminal activity, and the existence or not of mitigating circumstances or aggravating circumstances. This witness, given the fact on the personality or character of the accused, are in no way different from others, and therefore the civil parties should be allowed to fully play their role as parties before this chamber. Now, if it is the case that your chamber agrees to the principle that the parties should take part in this part of the debate in active fashion, this does not in any way prevent you from regulating this participation if you so desire, for instance, with regard to speaking time being allotted to the civil parties, as you did today already, because, well, we only speak 10 minutes and the other parties have 40 minutes speaking time. But this difficulty, which you perhaps anticipate with regard to the management of speaking time of the different parties in future hearings, should not cause you to put in question the participation of civil parties in these proceedings, a principle which is a principle that you have upheld from the outset in this case number 1. And here we are not at all entering into a discussion about case number 2. Finally, I would like to recall what Maître Roux said. Certainly in support of a different argument. We should not spoil the progress and the step forward. We should not spoil or cancel all the efforts that have been made over the last few years. Thank you.
ជាង10ឆ្នាំមកហើយនោះប៉ុន្តែចំណុចនេះគឺយើងពិតជាខំប្រឹងប្រែងដើម្បីទទួលនៅភាពសុក្រិតទាំងអស់គ្នា
The President. Next, the Chamber would like the civil party lawyers representing the 4 groups to make their observation in relation to whether the civil parties have the right to put questions to the witnesses called to testify regarding the accused character. You have 40 minutes altogether. Hong Kum Suan, Mr. President, thank you, Your Honors. In the decision concerning the submission or the rights of the civil parties to put questions to the witnesses regarding the character of the accused, on behalf of civil party group 2 and 4, I am here to present our joint comment of the two groups. First, we would like to tell the court that in our internal rule, the internal rules of the ECCC, Rule 23, as quoted by the co-prosecutor already, I would like to add briefly that the creation of the law on the extraordinary chambers in the courts of Cambodia by the United Nations and the royal government of Cambodia. In the agreement, they plan to put the most senior people and the most responsible people of the Khmer Rouge regime on trial. And the parties to the proceedings include the civil parties, and that the Criminal Procedural Code of Cambodia and the Cambodian law are to be used if the internal rules of the ECCC have not fully covered the main substance that of the law, that we need to use these national laws. And regarding Rule 23, the civil party action by victims, which states that paragraph 1A regarding the participation of the civil party in the criminal proceedings, we are here to support the prosecution, of course. However, if we look at Rule 23.7, which states as it is that any victim participating in proceedings before the ECCC as a civil party has the right to be represented by a national lawyer or a foreign lawyer in collaboration with a national lawyer as follows. And Rule 23.7a states that victims shall have the right freely to choose from amongst national lawyers and foreign lawyers who are registered with the Bar Association of Cambodia. In order to facilitate this choice, such persons shall be provided with a list of lawyers referred to in Rule 12.2a. So it is about the list of the national lawyers. Here, the rights of the parties are precisely set forth. So the victims who would like to join as the civil parties are entitled to legal representatives and counsels. So as a victim who can explicitly express their physical and emotional damages as the consequences of the crimes alleged, they are entitled the right to take part in the full proceedings. So here the civil parties have the right to counsel. And in Cambodian law, we use the term lawyer. So lawyer, whether the lawyer for the defense counsel or the lawyer for the civil parties, are to serve the interests of their clients. So as a lawyer and our clients, the civil parties here who previously are victims. So victims are here to express their suffering and the damages and that they are here to claim civil reparation and compensation. And regarding their statement or rights to make their submission in relation to sentencing, they can do so to support the co-prosecutor. But the civil party is not just here to rise and then say that we here are to support the co-prosecutor in sentencing. I think that is not enough for the full rights of the civil party are exercised. So if so, why should we have been participating in the proceedings for this far? We are here to show the court the damages, the consequences of the crimes committed by the accused toward our clients. And we, the civil parties, have noted all the details expressed or debated in the court, and we will put in our final submission these notes. So on behalf of civil party lawyer group 2 and 4, we would like the President to grant the rights or recognize the rights of the civil parties to put questions to the witnesses who are testifying on the character of the accused in the very near future. I would like my co-counsel to share the floor. Thank you. The President, Civil Party Lawyer Group 3, you may now proceed.
Ms. Trusnaprus, Mr. President, Your Honors, I will say that I was very much surprised by the issue that is presented to us today. It is certainly because I belong to the civil law tradition, which explains maybe that it may not have even come to my mind that this issue would be raised. However, since it is raised, I think that it is necessary that I respond. And I will tell you that I had planned to speak exactly in the same way as the co-prosecutor did. Indeed, just as the co-prosecutor, just as Maître Roux at the start, it is indeed for me indisputable that the civil party's presence in this trial, in a hybrid trial, in an international trial, this presence, for me, absolutely needs to be acknowledged. The civil parties are fully part of this trial as of the moment they have joined as such, and this in view of the legal dispositions. And it is obvious here, and I'm not going to bring up the articles that were already have been reminded by my colleagues, the Article 23, for example, of the internal rules, that allows me brings me to an observation, since it was indicated to you earlier by the defense that the civil parties were here to express their suffering and to ask for reparations, which is indeed the case, of course. But it is also provided in Article 23 that the civil parties also are involved in supporting the prosecution, in prosecuting people accused of crimes under the ECCC's jurisdiction. So it's exactly the same thing in civil law trials in which civil parties come to support the prosecution, and they do participate in the totality of the proceedings. And we did not yet mention, however, and again, while with reference to the internal rules, articles or the rules 90 and 91 of the internal rules, which deal with the questioning of the accused and of the questioning of the other parties. And in the context of the questioning of the accused, after questioning by the judges, the co-prosecutors and all the other parties and their lawyers shall have the right to question the accused. All questions shall be asked with the permission of the President, except for questions and Rule 91, the co-prosecutors and all the other parties and their lawyers shall be allowed to ask questions with the permission of the President. And there is therefore no difficulty involving these rules. And on top of this, Cambodian law also authorizes the presence of the civil parties at every level of, at any stage of the proceedings. And therefore, the civil parties might present their observations during the hearings. And Article 326 of the new Criminal Code of Cambodia supports what I just said, as I was referring to the rules, because the prosecutors, the lawyers, and the civil parties must be allowed to ask questions, and all of the questions, of course, must be authorized by the President. So I am therefore also taking the liberty of referring to decision of the preliminary chamber, which came into play in reference to case number 2. It was on the 20th of March 2008. It is a decision related to the civil parties responding to matters of provisional detention. And the preliminary chamber indicated that contrarily to what was decided in the ICCC, the internal rule provides that once the civil party has been joined, has applied, may participate in all of the stages of the proceedings according to Rule 24 of the internal rules. It is not necessary to prove a specific reason as so I believe, therefore, that the civil parties must benefit from the possibility of intervening at any level in the proceedings. Of course, naturally, with the authorization of the President, and this holds as well for the other parties, because these articles involve and bring all of the parties and put them at the same level and put them in the same context. And I think that this is extremely important to understand. So this being said, I believe that it is also suited to remind that the civil parties are represented by lawyers who are free and independent. And the accused, however, had the possibility of questioning through his counsel the civil parties. And his defense counsel used this right with a specific objective in mind, the ascertainment of truth, of course, and the interest of their client as well. And at certain points, they even believed that they had no questions to put to the civil parties. The civil party lawyers also would like to have the same possibility, the same choice, and they are fully part of these proceedings. They must therefore have the possibility of being able to question the accused regarding his personality, and also questioning the witnesses and the experts also in regard to his personality. And this, of course, with the simple objective of really understanding what might have happened, and in the interest, of course, of our clients, but also in order to participate in the ascertainment of the truth as well. The civil party lawyers are here as well to partake in a work of justice and to participate in a trial that must be a fair trial. Therefore, they are fully entitled to have their full place in this trial and at every stage of these proceedings. And as the co-prosecutor mentioned, this, of course, might modify the rules. Modifying the rules right now would be discriminatory and would not at all be understood. So I believe that it is maybe the chamber has a few questions regarding indeed the speech time that may be granted to the civil parties, of course. But this is a problem of organization only. But the principle in itself, the principle of the freedom of expression of the civil party lawyers, even in regard to this principle cannot be challenged. The civil parties must be able to participate at all of the stages of the proceedings.
The President, Council Tisrina, you may now proceed. Tisrina, Mr. President, Your Honors, and distinguished members of the court. The co-prosecutors and the civil party of the other groups have already made it clear in relation to this matter. However, I would like to add on top of what have been raised. As to the rights of the civil party to participate in the questioning the witnesses regarding the character of the accused. Since Internal Rule 23 has been already expressly quoted, I would like to quote from the Cambodian law, Article 325 of the Criminal Code of Cambodia, Criminal Procedural Code of Cambodia. In that article, it is about the questioning of the accused. Paragraph 2 states that after the president of the court put question, then the co-prosecutor and the parties are allowed to put questions to the accused. Another relevant article is also seen important, Article 326, which is the hearing of parties. It states that the presiding judge shall listen to the statements of civil parties, civil defendants, victims, witnesses, and experts in the order which he deems useful. The presiding judge can listen as witnesses to judicial police officials and judicial police agents who conducted the inquiry. In the second paragraph, as it referred, the prosecutor of the kingdom, the lawyers, and all the parties may be authorized to question the accused. All questions shall be asked with the authorization of the presiding judge. As referred to these two articles, the general substance has already been well covered concerning the debates in the proceeding, and so far the proceedings have been fully follow these articles with the order starting from the prosecutor and then the civil parties and the defense counsel. So regarding other facts, which is new fact concerning the character of the accused, as long as the fact is being put before the chamber, the parties to the proceedings will maintain their rights to put questions to the person concerned. And in relation to this character of the accused, it is very related to the alleged facts. Therefore, the parties to the proceeding are entitled the rights to put questions. So we would like the chamber to guarantee that the civil party lawyers and civil parties will still have the rights to put questions to the witnesses. And I would like to share the floor with Mr. Alain Huertner. The President, Mr. Alain Huertner, you now may proceed.
Je souhaiterais à présent donner la parole à mon confrère, Maître Werner, avec votre permission, Monsieur le Président.
Mr. Werner, thank you, Mr. President. Let me please first share with you the fact that indeed our group was also very much surprised last night when we understood that you wanted to bring up this issue and hear what we have to say. My colleagues and the international co-prosecutor brought up a certain number of legal points, and I don't think we should get back to them. Of course, we support all of the arguments that were presented on this side of the bar. And let me please first tell you that regarding law, up until now, the criteria regarding questions are that these questions must not be repetitive and that the question must be related to the issue at hand. It is these criteria that we have been abiding to for the past 5 months, and that and I believe that you have adopted this in a fair way as well. And we have tried as much as we could to abide by this. It is only these 2 criteria that were retained. So I would like to do this, and I thought I could do this before you render your decision. There are indeed 2 different aspects here. There are the pleadings, and there are the questions. The questions that the parties put during the hearings, and regarding the pleadings, you did render your decisions. Regarding the pleadings, we did not agree with the defense. In fact, we didn't even agree among ourselves, among the different civil party lawyers, and you decided, and that's one thing, But the question of knowing if the civil parties might be able to put questions to the experts and to the witnesses is a completely different question. And back then, when we were pleading on both sides of the bar regarding the issue of whether or not we can plead, Maître Roux at one point brought up the possibility of calling in Mr. Robert Badinter, who would explain to you what happens in French law. Let me please tell you that if Mr. Robert Badinter had come with him, and with him the highest authorities in French law, all of them would have told you that indeed, the civil party lawyers are authorized to put questions to all of the experts and to all of the witnesses in all criminal trials in France. And the situation is not different to my country or in other countries based on the civil law system. Nowhere, when there are civil parties involved, nowhere is there a distinction between different experts and different witnesses. Nowhere. So let's please be clear. You would therefore be creating a distinction that does not exist. And of course, it would be an enormous form of regression. Let me tell you something else as well. You are asking us the question today regarding witnesses who are called in to testify in regard to the accused personality and only that. But let's please be clear. Since the end of March, since therefore the beginning of the substantive hearing, practically all of the witnesses and all of the experts spoke in one way or the other, directly or indirectly, about the accused's personality. And all of the civil party lawyers, practically all of the civil party lawyers, for the past 5 months, put questions to the experts and to the witnesses regarding the personality of the accused. In June, myself, I directly put questions to the accused, and the accused was stating that he would not go into the cells because he felt guilty. And he said the day before to Judge Levin that he was himself a coward. And I confronted the accused, and I asked him if that it was not because of cowardice or because of pity that he would not go into the cells, but because he was opportunistic instead, and that he did not feel any compassion. I asked him that question personally, and nobody objected to that. Nobody objected, neither the judges nor the defense, and the question was considered as perfectly appropriate, and the accused did, in fact, answer me. On the 28th of May, Dr. Etchison, I asked him 3 to 4 questions, myself, directly to Dr. Etchison, regarding the creativity of the accused. And Dr. Etchison, for practically full hours, spoke about the accused's zeal and inventivity, and this aspect of the accused, which explains that he multiplied the torture methods at F21. David Chandler, on the 6th of August, spoke in depth about the personality of the accused. The fact that the accused's former job as a school teacher corresponded so well with what he was doing at S21, and we put questions to Mr. Chandler regarding this. And these are experts, but not speaking about the witnesses. François Bissot, on the 9th of April, François Bissot spoke in depth about the accused's character, and I put questions directly to François Bissot in order to know if the character of the accused, of the personality of the accused, in order to know if the accused's tastes for French culture, his intellectualism, had allowed François Bissot to convince the accused of his innocence and therefore to save his own skin. And I asked him if he did not believe that for other people, for Khmer people, because of the accused's character, if this he would not have been able to convince the accused in the same way. And Mom Nai, on the 14th of July, I put questions directly to Mom Nai regarding the character of the accused, on his tendency to directly denounce people to send them to S21. And Mom Nai answered me directly. If I had had more time, I would have gone back to the transcripts, and I would have found all of the examples that prove that we put questions directly regarding the personality of the accused. And I think more than 75% of the witnesses and the civil parties were directly questioned by the civil parties. So the situation is the following.
The law, Jurelex said lex, the law is perfectly clear here, and my colleagues recall that. Practice is unanimous in all civil law countries, and the internal dynamics over the last 5 months of this trial show that we have all been in a position to ask questions from witnesses and experts concerning the character of the accused. So if you stop it now, we'll be in an impossible situation. We asked all the witnesses and all the experts and regarding character, because they were not called to the bar to speak specifically on character, and once you call them to the bar to speak specifically on character, then we would be prevented from asking questions. That is impossible. It's an impossible situation. Thank you.
The President, now it is appropriate time for our lunch break. So the chamber will adjourn for lunch, and it will resume in the afternoon starting from 1:30 p.m. For this afternoon schedule, we will hear the observation by the Defense Council. After that, the judges will retire for the deliberation to make our decision. Then we will inform the chamber, the parties of the decision, and we can start questioning the accused on the character. Security guard take the accused back to the detention facility and bring him back before 1:30 p.m. The hearing is adjourned. All rise, says the greffier.
Il le ramener ici même à 13h30. La greffière, mesdames et messieurs, veuillez vous lever.
The President, please be seated. The chamber is now back in session. For this afternoon proceeding, the chamber would like to give the floor to the Defense Council to make their observations and to make it brief on the question whether the civil parties shall be entitled or granted a right to ask questions on the character issues to the accused and the witnesses. You take the floor. Kasabut, thank you, Mr. President. Good afternoon, Journalists, ladies and gentlemen. Generally speaking, based on Internal Rule 91.2 and Article 326 of the Code of Criminal Procedure, all parties can raise a question. Specifically, on the issue of the character or personality of the accused, and as it is decided by the chamber, the civil party lawyers have no right to make their submission on sentencing or on the legal matters related to sentencing. So, what is the purpose of putting questions on the character of the accused? What is the gain for the civil party? It is not to maximize or minimize their civil claims. The question of the character of the accused has only sole purpose is whether to prove the guilt or the innocence of the accused. And the civil parties have no obligation in the prosecution or in legal submission regarding this matter, so they shall not be granted the right to ask questions on the character to the accused or to the witnesses. That is point one. Point two, In the submission regarding the legal aspect, the chamber weighs the equality of arms in order to ascertain the truth, to find justice. And justice is not to be done for only the civil party or the victims, but it shall be done for the accused as well. Therefore, justice can only be achieved when there is an equality of arms. And how can we achieve that? We can see that there are two co-prosecutors representing the victims, and they have the obligation to put questions on the accused's character in order to provide the burden of proof on the accused, or to provide inculpatory evidence on the accused. And on the contrary, we, the defense counsel, will have to find the exculpatory evidence for the accused. And if the four groups of the civil parties are granted the right to put questions to the accused regarding his character, then certainly it can be seen there is no equality of arms. And of course, this is at the discretion of the president and the judges of the bench to find justice. And this is my observation, Mr. President. And I would like my international colleague to make further submissions. The President, the International Defense Council, you may proceed.
Merci, Monsieur le Président.
Maître Roux, thank you, Mr. President.
Nous sommes dans, tout le monde l'aura compris, dans un débat.
Well, all of us will have understood that we have entered an extremely interesting area of debate, and
La décision que prendra la Chambre sera
the ruling of the Chamber on this matter will certainly be scrutinized by jurists, both national and international, who have been following all of these trials, and ours in particular, and who follow our trial on the issue of victim access to international proceedings. Now, you have this morning handed down a first decision which the defense was waiting for in order to determine the orientation selected by the Chamber. Things have become clearer now. As far as the defense is concerned, we had always stated that civil parties should not intervene on the issue of sentencing. Now, at the beginning of my observations, I would say that I was very much flattered by the fact that my colleague from the Office of the Prosecutor quoted me at length, and I'm not in the habit of contradicting myself or stepping back from a position I've put forward. But in this quoting game, of course, I can also take part, and I will begin by quoting you as well. You said before the Chamber, all of the witnesses will help you to come to a determination both as to guilt and as to sentence. And then I could simply stop pleading, since the Chamber has just decided that the civil parties may not intervene on sentencing. They have no ground to question witnesses who will be coming into play on determination of the sentence, because it's clear that when you are discussing character, you are obviously looking to sentencing. And when one analyzes the personality of the accused, it is because one is seeking, on the basis of that personality, one is seeking to find the means to individualize the sentence. We're dealing with criminal law here. And what is the fundamental principle of criminal law since Mr. Bekaya? It is the principle of the individual nature of the sentence. In other words, confronted with identical facts, two accused may be sentenced to different penalties because their personality happens to be different. That is what personality or character is about. This goes to an individualization or personalization of the sentence. And at this stage already, one might ask, what does this have to do with the request for indemnification that is lodged by the civil parties? Because the role of civil parties is, one, to express their suffering, and two, to seek redress. So what role can the personality or the character of the accused play in regard to these two aspects? And continuing on what my distinguished opponents have said, Maître Werner explained at length that for the last 5 months, the civil parties on numerous occasions have had opportunity to put questions going to the character of the accused. Duly noted. Therefore, you put all the questions that you intended to put regarding the character of the accused. You know today everything that you wanted to know. So why would you want now, on witnesses that will deal exclusively with character, why would you want to ask more questions? And you gave us a detailed presentation of all the questions that you had occasion and opportunity to put to the accused, to the experts, and to various witnesses. We can consider that you have acquired sufficient knowledge in this field. And my colleague, Maître Werner, very ably invoked civil law. Well, that's interesting. I heard you from the beginning of these proceedings that we should not lock ourselves in the realm of civil law. But when it suits you, you invoke civil law. So you haven't, since the outset, you have not ceased to attempt to go beyond the boundaries of the civil law. You explained to us at length that you had the right to speak to sentencing, that you might even have the right to call experts on that issue. So at all times throughout the proceedings, you try to outflank the role of the civil parties. Well, please allow us on our side of the bar to revisit civil law as well. Because, Mr. President, distinguished members of the court, the co-prosecutors and counsel for the civil parties are perfectly right in a context of pure civil law, it is obvious that the civil parties are entitled to question all of the witnesses and all of the experts. I can confirm this. There is absolutely no argument about this. In a national trial under civil law, this will happen. The problem, however, which we are attempting to clarify here, is how can one transpose rules of national law in international proceedings for a trial that deals with mass crimes. And you will understand what I mean. When one is in a national civil law trial where there is an accused who has committed one murder, and when you have one, perhaps two civil parties applying, well, if the civil party lets his or her suffering overflow, that might happen. But it won't go any further than that. However, in proceedings such as this one, dealing with mass crimes, if you have 1, 2, 3, 5, 10, or 20 or more civil parties who come and let out their legitimate suffering, then we find ourselves in a situation that is unmanageable from the point of view of a fair trial, because the accused is no longer facing one prosecutor, but 20, 30, 50 prosecutors. And when I said earlier that we were not at the marketplace, but in a forum of law here, that is what I wanted to say. And it is even more complex in our case, where you have an accused who is pleading guilty, and where we find ourselves in a situation that is totally unexpected, where someone is facing all these persons, accusing them, who hardly puts up a defense. And as I said this morning, is hearing words of such violence that it's as if he were pelted with stones. And I repeat for my civil party colleagues, you took yourselves to be prosecutors. And this is the problem which we have to face today. You thought you had become prosecutors. I was going to say, how could you? Don't you trust the office of the prosecutors? Are you not satisfied with the work performed by the prosecution? Why are you attempting to replace them, to outflank them? Let me quote a French saying, which says, if you sow the wind, you will harvest the storm. And distinguished members of the civil and colleagues of the civil parties, you did sow the wind, and today you're harvesting the storm. You were surprised that the chamber would ask itself whether we should continue to let you behave as if you were prosecutors. That is the question that the chamber is asking you to answer. And so yes, indeed, you have civil law on your side. That's true. Looking at the letter of the law is on your side. But the law is a living organism, and More specifically,
dans un tribunal.
we all know here that we are in a tribunal that creates law.
Alors, à l'attention
And
de
so
mes confrères et de la civil law,
I would tell my colleagues,
je
and
voudrais rappeler les débats
looking to civil law and to
que
common
nous
law,
avons aujourd'hui
I would
dans
like to
mon pays
recall the
sur la
debate
place, justement,
that is in progress in my country today regarding the place of victims in a criminal trial. And since my colleague Werner had very opportunely
un grand d'entre les
quoted
un grand avocat,
an eminent jurist, an eminent minister, an eminent president of the Constitutional Council, and I mean here Mr. Robert Badinter, I would like to recall what Mr. Robert Badinter said in an article published in the newspaper Le Monde, which was entitled, "One should not confuse justice and therapy." We are at the very heart of the subject matter here. And I read,
dit Monsieur Badinter.
quoting Mr. Badinter, "One must recall that criminal justice does not have the mission of acting as a therapy for the suffering of victims. Its function is of an enforcement, deterrent, and expressive nature because it expresses the values of society. But it cannot be considered to have as an objective to provide therapy. In the name of the suffering of victims, calling upon the solidarity of the entire society, we must not alter the difficult and delicate balance of criminal justice, which is based on the principle of a fair trial, which is enshrined in the European Human Rights Convention. But, Mr. Badinter adds, we are seeing a trend occur, drifting away, and to claim that you are on the side of the victims is politically always beneficial. Who could be opposed to this? We live in a society based on emotions, which wants to express compassion. Nothing can mobilize emotion more than crime and the suffering of victims, multiplied by the media effect and the power, the graphic power of television. This feeds the revenge, the urge to seek revenge, which lies at the very heart of human reaction when confronted with a horrendous crime. But justice cannot be confused with revenge, nor can it be confused with compassion for the victims. This is why it is so difficult to practice. I apologize for this somewhat philosophical digression, but I believe that in the face of stakes as great as those that we are contemplating, it is good to remember our principles and our difficulties. Therefore, I would like to suggest to the Chamber that it be pragmatic. I do indeed believe that it would be
disant que les parties civiles
a
n'ont pas
serious
le droit
issue if the chamber were to hand down a principal decision stating that the civil parties are not entitled to question all of the witnesses who appear in a trial where there are civil parties. But I also believe that the chamber should take account of the particular context of the Duch case, and the chamber should hand down a specific decision, specific to the Duch case. And the Duch case is the case of an accused pleading guilty. And if the chamber is willing to look to common law, I have on several occasions in international criminal courts assisted persons pleading guilty, and I negotiated plea bargainings with the prosecutors. And when an accused pleads guilty before an international criminal court, please listen carefully, an agreement is struck with the prosecutors, enabling the accused to bring forward character witnesses, and the prosecutor does not challenge them. The prosecutor refrains when someone pleads guilty in common law, refrains from questioning or challenging character witnesses. That is the solution. That is the solution. Let us be pragmatic. Let us respond to the case we have at hand. Adapt your decision to the circumstances of the Duch trial. And at the same time, and again, in order to be pragmatic, I dare make a suggestion to the chamber in order to avoid completely depriving the civil parties from burning questions they may wish to ask. And the chamber could well decide that in this case, the civil parties will address the office of the prosecutors, thus putting it back in its full role, and ask the office of the prosecutors to ask questions that the civil parties would have liked to ask directly. Well, I believe that we could perhaps go forward with such solutions. Let me add still that with regard to the defense, I could also understand the fact that the chamber decide to make a difference between, on the one hand, accused and witnesses, and on the other, experts. I would personally be willing to accept that the civil parties be allowed, either directly, either through the prosecutor, be allowed to ask questions from the experts. But please, once again, on the condition that they are reminded, and Mr. President, forgive me for insisting, you've already done this. Unfortunately, you were not always followed in your admonitions, but they must be reminded that the questions that they put can deal exclusively with their suffering and indemnification. Thank you.
សំណងជំងឺចិត្តតែប៉ុណ្ណោះមិនឲ្យលើសពីនឹងទេសូមអរគុណ
The President, after having heard the remark made by the Defense Council and having listened to the civil party lawyers' comments, the Chamber would like to retire to deliberate, and we will adjourn for 30 minutes now. We will resume after 30 minutes.
សូមអញ្ជើញក្រោយចូល